my senior friend, my lord. I'm mentioning item number 24, my lord. My lord, we need further 2 weeks time to raise, my lord. We are supposed to get a record, my lord. So we need further 2 weeks time, my lord.
2013 matter.
Yes, my lord. That is the problem, my lord. Because of bifurcation of the department, my lord, that record is not traceable, my lord.
What is
So,
the issue about?
My lord, regarding the private respondent, my lord, he claiming to be SC, my lord, he got a certificate and avail some, my lord, benefits that have under
record
silence.
from the state level should be provided.
So the SLC has, my lord, said that under order has been under silence, my lord.
When can you get it?
My lord, after vacation, my lord.
2013 matter. 2013. 11 years.
I understand.
You can't be so liberal about this matter. We are fixing it on 17th.
19, my lord.
17th. 19th is hardly anything. 17th.
My lord, 19.
Why?
My lord, I am not available on
18, 19th, all right.
19, my lord.
19 December at the request of Mr. R.K. Arthur, learned governor. You are SC Tribal Affair.
Right.
SC Tribal. Mr. M. Soronia, learned counsel, does not object to the prayer made. Mr. P. A. Ahmed appears for private response.
Eight.
Yes.
My lord.
19th
Right.
December.
May it please your lordship, my lord, I may be allowed to move this application tomorrow or day after tomorrow, anything. Matter relating to, my lord, imposition of interest on refund made under central
Tomorrow?
DPO.
But this writ petition by the filed on 5/12. I think it's tomorrow day after.
Day after.
Okay.
May I please. IA in WPC note 7607. This is disposed of on 2011. There is a small mistake in typing, my lord. The actual measurement of the land written as 25 biga, 25 kotha. It should be
Thursday?
Thursday.
Huh?
My lord.
May I please offer? I have to mention item number 30 and 31, your lordship. I may allow to withdraw. Matter becoming
30 and 30 what?
Yes, sir.
The request of the submission of the learned counsel to the petitioner submits on instructions that the restrictions have become instructed according to the same stands dismissed as not pressed. Interim orders, if any, stand vacated.
Sir.
May I please, your lordship? Lordship, I beg to mention for listing of a writ petition matter pertaining to land settlement.
Admission orders, motion, what?
Lordship, for orders.
For orders.
Lordship, kindly any date next week.
Any date next week. Let it be on 17th December.
Obliged, Lordship.
May I please, your lordship, I beg to mention item number 20. Due to some personal difficulty, the council D. Sharaf will not be able to take the matter today.
You wait, this is a connected matter.
Yes.
Wait. This is a connected matter.
Yes, sir.
Yes. You can't make your mention of only item 20. These are all connected matters. It begins at item number 12.
Please, your.
Yes.
May I please, your lordship, I beg to mention for listing on mention for listing.
Listing in
Motion.
what? Motion, admission, orders?
Motion.
Why? Fresh matter.
Yes.
When was it filed?
And if the
All right, subject to clearance of defect.
May I please, lordship. Item number 23. May kindly pass over for the day, lordship.
20?
3, your lordship.
20?
Some instructions are awaited, lordship.
Huh?
Some instructions are awaited. Kindly pass over for the day, lordship.
23 passed over for the day. At the request of counsel for the Mr. S. Saha.
SK Saha.
S.K. Saha.
Yes, sir. Deeply obliged.
Yes.
Lordship, in this case, we have been directed to obtain the instructions. Lordship, may I pray little bit accommodation, Lordship, for 2-3 days. Eviction.
How much time do you require?
2-3 days, Lordship. I'm trying to contact the SDO today itself, Lordship.
Then go to next week.
Lordship.
We'll have it on 17th.
Lordship.
17th December at the request of Council, learned senior government, additional senior
Additional.
government council, appearing for the respondent. Matter be listed on 17th of December. S.K. Soikia appears for the
Interim is there.
interim order passed earlier will continue till the next date fixed.
Much.
Yes.
May it please your lordship. My lord, the petitioner is your lordship, my lord, against the proposed demolition of his flat, my lord, tomorrow. Now what happened, my lord, the petitioner,
Yes. Carry on.
the petitioner purchased a flat in the ground floor of a, my lord, ground floor 3 building. The sale deed has been registered and he is in occupation of the land, of the flat, my lord. So what happened, my lord, the construction that was made in the ground floor, which he is utilizing as his office, that was, my lord, in the original plan, it was a little different and it has been, my lord, rearranged by the builder. That I didn't know, my lord. After the, my lord, I had purchased the flat, there was a notice to the, my lord, builder. My lord, may I take your lordship, my lord, to understand the ground situation to page 73 before I take your lordship to the, my lord, impugn order. Page 73 is the, my lord, approved plan.
Yes.
In the approved plan, in the, my lord, chart at the bottom, my lord, your lordship will find partly parking and partly a flat. This
Yes.
is the ground floor plan, my lord. This is the approved plan. Now, what the builder did, he had, my lord, rearranged the entire thing in order to, as per his explanation, my lord, the driveway was very narrow, so he changed it. And page 74 is the, my lord, construction that he has made. The entire left side, your lordship will see the parking, and the, my lord, the flat is, my lord, on the front.
Yeah.
Now, my lord, this is admittedly, my lord, a violation of the, my lord, approved plan. And therefore, my lord, he filed an application. In fact, my lord, the builder.
You purchased the ground floor flat.
Ground floor flat. This is the fact that I am concerned with, my lord. There have been other violations that I am not concerned with, my lord. I am the, my lord, bona fide purchaser for this, my lord, flat, and there was some rearrangement made. And because of the violation, my lord, the notice was issued. Now, so far as the, my lord, builder and the landowner is concerned, there is a dispute between them. The GMDA said that both of you should file a joint application for registration of the project and for issuance of the occupancy certificate. Now, because of the, my lord, dispute between them, they have not, my lord, filed it. Therefore, my lord, I approached the RERA saying that they should be directed to file the application so that, my lord, my occupancy is, my lord, this is validated. And if there is any violation is there, my lord, then, my lord, this is compoundable. So unless, my lord, they file the application, the GMD authority also, my lord, cannot do anything. But in my application before the RERA, I asked for a direction that they should be directed to file the application for the occupancy certificate. Joint, because, my lord, the GMD required that both the landowner and the builder, they should sign it, my lord, jointly. Now, the builder also, my lord, approached the RERA for registration of his project, my lord. Now, both the matters were tagged together. I am not a party to that, my lord. In the, my lord, the application filed by the builder, the RERA has imposed a fine of rupees 2 lakhs because of continued violation. Against that, my lord, he preferred an appeal. And in the appeal, my lord, that is the primary order I am, my lord, assailing before your lordship now, that your lordship finds at page 151. I am not a party to the appeal, my lord. And I have never been issued with any notice by the GMDA. Whatever notices were issued, my lord, those were only to the builder and the landowner. Now,
Yes.
by this order, if your lordship comes to page 152, paragraph 4, in the memo of appeal, has your lordship got it?
Yes.
Page 152. In the memo of appeal, document number 12 at page 165 is the letter dated 29/9/2023 issued under the hand of the Chief Executive Officer GMDA and addressed to the appellant as well as the respondent number 1, informing that for considering the matter with regard to issue of occupancy certificate, the builder is first required to clear the parking area and also to clear the terrace by demolishing the obstruction constructed by the builder as well to submit a build drawing in form number such and such duly signed by the respondent number 1. The document number 14 at page 167 of the appeal memo is the letter dated 26/10/2023 issued under the hand of the appellant and addressed to the Chief Executive Officer GMDA, informing inter alia that the removal of the construction of the terrace floor and the rearrangement of the parking area will be carried out at the earliest. I am concerned with this, my lord, rearrangement. Important to note from document number 16 at page 170 of the aforesaid appeal memo, which is the letter dated 18/12/2003 issued by the Chief Executive Officer GMDA and addressed to the appellant as well as the respondent number 1, informing that despite issue of the letter dated 29/9/2023, the parking area as well as the demolition of the unauthorized construction on the terrace floor was yet to be carried out. This is important, my lord. From the exchange of letters above, there is no dispute to the fact that the issue with regard to grant of occupancy certificate is pending with the competent authority due to inaction on the part of the appellant in carrying out the exercise of rearrangement of the parking area and the demolition of illegal construction on the terrace floor of Supriya Residency. The respondent number 1 have also categorically taken the stand that until and unless the activities are sorted out, rectified, he will not be party to the application for occupancy certificate. My lord, the respondent number 1 is the landowner. It now appears that the matter with regard to grant of occupancy certificate is at a stalemate unless the appellant carries out the direction given by the GMDA at document number 12. Then, my lord, your lordship may skip paragraph 5. Paragraph 6 is the, my lord, operative part. As the primary issue involved in the present appeal is with regard to the legality and validity of the order of RERA dated 2/7/2024, imposing penalty upon the appellant to the tune of rupees 2 lakhs for continuous violation of the subsection 2 of 59 of the Act, the same would stand for adjudication in course of time. Firstly, the respondent number 3, the GMDA authority, carry out necessary exercise in terms of his direction contained in the letter dated 29/9/2023 so as to end the stalemate involving initiation of due process for grant of occupancy certificate. Any date fixed for carrying out the demolition exercise by the GMDA shall be intimated in advance to the appellant as well as the respondent number 1. Let the required exercise be carried out within 4 weeks from today. Now, my lord, the builder has now, my lord, further order to be passed on the next date. Compliance of the direction above be brought on record by the concerned party by the next date. Now, in the meantime, my lord, the builder has today, my lord, given this copy which has been sent to him, this notice order, my lord, that tomorrow is fixed, my lord, at 10 a.m. for demolition of the, my lord, unauthorized structure, including the ground floor. I am concerned with the ground floor. Now, my lord, since the matter is fixed day after tomorrow before the RERA, my lord, appellate authority, the GMD has issued this notice to my lord demolish tomorrow. My lord, my submission before your lordship is this, my lord. I am
Where is that letter of the, where is the document number 12?
document number 12 is dated 29/9/2023 that your lordship will find at my lord 29/9/2023.
Page 1.
112, my.
112.
My lord. This is a letter, my lord, addressed by the GMDA to Ananda Sharma is the, my lord, landowner, and Nishanta Goswami is one of the partners of the builder.
What is the terrace? What is the
Terrace part, my lord, I am not concerned with terrace, or there has been, my lord,
no,
some
no, no.
deviation.
The direction is to clear the parking area.
Yes, my lord.
What is the parking area?
Parking area is where my flat is there, my lord. Parking area, I have shown your lordship, my lord, page 73, that, my lord, the parking area has been rearranged, my lord, from the approved plan. Approved plan, your lordship finds at page 73. And the, my lord, construction now the builder has done before selling the flat to me is at 74. And, my lord, his justification is that in the earlier approved plan, the driveway was very narrow. It was difficult, so I have rearranged it.
Now, when did you come to know about the order of RIAT?
My lord, I have come to know, my lord, I have stated, my lord, only on the last week, my lord, because, my lord, the builder informed that this is the order passed. And
You should have approached the RIAT immediately, seeking modification of by getting yourself
my lord,
implicated.
RERA has already, my lord, passed that order with the appeal, where I am not a party, my lord.
That's right, but you can approach the RERA for arraying yourself as a party and getting the order modified till the time
My
it is
lord,
heard.
it's an appellate authority. Appeal is against an order of imposition of 2 lakh
Whatever it may be.
rupees as fine.
Whatever. Now, without the facts are not very clear whether this portion which is under you has been shown to have been occupied or not. It's not clear from the order.
My
of
lord,
the
that,
RIAT.
yes, my lord, that is also, my lord, my grievance that I am occupying this. The cell deed I have annexed,
Right,
my
but
lord.
how? Who is going to place it before the RIAT?
My lord, in fact, that has been placed by the builder before the, my lord,
How do you
RERA.
know?
My lord, that your lordship will find, my lord, in the application that was filed before the RERA by the builder. In the appeal also, my lord, it is there. 130 is the, my lord, appeal. What is the paragraph?
Where is the appeal? Appeal memo?
Page 131. 131, my lord. The appeal starts at page 130. Yes, appeal starts at, my lord, page 128.
You are named as a respondent.
In the appeal, my lord, yes.
Yeah.
Appeal, no, I'm sorry, my
Page
lord,
number
this is not the appeal.
129.
Yes, my lord. In the appeal, my lord, they have made me a party, and that is how, my lord, I came to know about it.
So then why did you not appear before the appellate authority? Presenting your case?
So in the meantime, my lord, the direction is there that, my lord, in
No,
4 weeks.
Appeal is filed. Are you saying that this order was issued without issuance of notice? Would not have been. Where you are arrayed as a party.
Notice was issued, my lord.
Then-
Notice of the appeal was issued.
Then you are aware of the proceeding going on.
Now, my lord, I am in such a position, my lord.
You are in such a position because of your own inaction. The moment you receive an order, a notice from the appellate authority, you should have approached the appellate authority. You sat quietly. And you are making a statement before the court that you came to be aware because the builder informed you. When you are arrayed as a party.
Yes, in the appeal, my lord, I am a
Yeah.
party. That's right. But my lord, this stalemate, to break this stalemate, my lord, the
We
appellate
can't
authority.
pass an order staying an order of the RIAT unless you tell us why as a respondent you did not appear. It's not a case that you were not heard or not given an opportunity.
No, my lord, that instruction, of course, my lord, I could not take when
That's right.
the notice was received, notice of the appeal was received, my lord.
So perhaps your best course of action would be to immediately approach the RIAT.
Unless your lordship grants me at least 2 days time, my lord. to
Why?
approach.
On what basis? Give us a reason to grant you a stay.
Because my lord, the tomorrow, my lord, they are demolishing it, my lord.
That is because of your inaction. You refuse to go and appear before the authority and present your case.
Appeal is in respect of my lord the fine that was imposed. And I do not have
Whatever
anything.
it may be, you are shown as a respondent. Now, if you have a cause to worry, then you should have, moment you receive a notice, you should have been there.
But there is my lord, hardly any time to.
How can there be? The order was passed in November, 13 November. This is 1 month since the order has been passed.
But in the my lord, in the main case, because I filed a complaint, and the issue is my lord where
You are aggrieved by the order of the RIAT, which was passed on 13 November, and it is 1 month. And in an appeal where you are arraigned as a party, there is no explanation why you did not appear or contest the matter. There is no
At least, my lord,
explanation whether notice was duly served upon you, not received by you.
but your lordship will look at the matter from another point of view, my lord. That the deviation that has taken place in the ground floor, my lord, that is componable. Whether componable or not, that can be.
We are not looking into this because this is not before us. This is before the appellate authority to look into it, whether it is compoundable, not compoundable, what fine should be imposed, whether demolition should be carried out. These are issues.
I am not aggrieved by the my lord the penalty that was that has been imposed on the builder. I am not aggrieved by that.
You approach the RIAT for modification of this order, that part of the order. You are a respondent.
I can file the application only on 12th, my lord, and tomorrow the demolition will take place.
We can't help you on that. You have to explain why the delay of 1 month has taken place if you are aggrieved by this in a matter where you are arraigned as a party.
In fact, my lord, that was
It could appear to be a step taken by the builder through you.
My lord, I got an order, my lord. I'd like to look into this in another matter, my lord. The appeal is in respect of the fine imposed, penalty imposed. And my lord, I do not have anything to say there, my lord. Because I have approached the tribunal, RERA tribunal, that they direct the builder and the.
No, we can go into everything, provided you explain to us why you did not appear and contest the matter.
Because my lord, that is with
Your name, you should have, if you are not aggrieved by the fine, if you are not aggrieved by the order which is appealed against, you should have filed an application to struck your name off. You are shown to be a respondent here.
Yes, my lord, that was not properly advised. But then, my lord, as far as the imposition of fine is concerned, he did not have. In fact, your lordship will see, my lord, the appellate authority has acted beyond this jurisdiction, my lord, knowing fully well that I am a party, and my lord, that
And we can't say that unless there is a specific statement that notice was not issued, or you are not given an opportunity to be heard.
that instruction of court, my lord.
Then, unless these specific instructions are there, why should we interfere with an order by RIAT? Yes.
Furthermore, I want to add one thing. He's challenging the order of the RERA, and RERA has a standing clause in High Court, and RERA has not been made party. RERA has not been made party. Challenging the order of the RERA.
That we do not. Because we have also not made the appellate authority a party.
Normally, appellate authorities are not made party.
But RERA is the standing counsel for all these projects, because these two orders for the RERA as well as the appellate authority. They have a standing counsel for.
We do not know.
Is there a standing counsel
Yes.
for a tribunal?
Yes, ma'am.
Huh?
Yes. He appeared in one or two cases along with me.
Tomorrow is an order of a district judge.
Well,
There is
RERA has
standing
appointed him, but I am only pointing out, my lord, that.
Who is the standing counsel?
But I don't know the name, my lord. He appeared in one or two cases. But they have a standing counsel.
We do not make the tribunals party.
So right now we are unable to help.
Lord.
We are unable to help because of facts not being treated properly. That's it.
My right, my lord, completely goes away, my lord.
You're right. You're approaching the 226, or rather 227. See whether there is an error. Where is the error unless you tell us on fact?
Or my lord, may I pray in this way, my lord? Because tomorrow, my lord, the time has been fixed at 10 o'clock.
Giving an interim order will amount to modification of that order
No,
by the real.
what I, my lord, submit is that even for approaching the, my lord, RERA appellate authority, if I, my lord, move at 10:30, my lord, it till 2 o'clock, my lord, if this is, my lord, postponed, maybe, my lord, the appellate authority may accept it. Otherwise, my lord, this will lead to multiplicity of proceedings.
No, it is multiplicity because you refused to or you did not appear before the authority, in spite of being made a part. And there is no information to show that notice was not served on him.
No, my lord, he did not contest because he was not agreed by that imposition of fine.
That he has to go and apprise the authority concerned.
This was not expected, my lord, only to break the stalemate between the, my lord, owner, landowner and the builder.
Yes, Mr. Bora.
He can help me, my lord.
My lord, already that police and all this machinery have not been generated, my lord. That
Huh?
demolition is full, that schedule, my lord, that time, police and all the administration work has already been done, my lord, for demolition tomorrow.
Let it be postponed till 2 o'clock, 1 o'clock, my lord. In the meantime, I approach the tribunal, appellate authority. Because this has not, my lord, put anyone into difficulty.
You are
Only
entitled to approach the tribunal today itself. You withdraw and go to the tribunal today. What is the point in staying it till 2 o'clock? If we stay it, we stay it. But there is no ground to stay there, interfering. In the absence of the facts
No,
pointed
my
out.
submission is that, my lord, when the builder is agreed by imposition of fine, my lord, I am not agreed by that.
But who is going to present your case? Somebody has to present your case.
This was not expected, my lord, only to break the stalemate between the builder and the landowner.
Mr. Counsel, you were a very senior counsel. You know that when an order is passed, the first authority would be to go and approach the authority for modification by presenting your fact. This order was passed not yesterday, 1-1.
That's right.
There also no explanation why the tribunal was not approached. And you are approaching today when the demolition is tomorrow. This notice was served to you on 6th.
No, this notice is on the builder.
Oh, all right.
No copy has not been endorsed to me, my lord. The authority knows that, my lord, I am there in the party. I am a party, and my lord, the copy ought to have been endorsed to me also. Only to break the stalemate between the, my lord, landowner and the builder, my lord, appellate tribunal says, my lord, demolish my building, my flat.
See, every ground that you are urging before this court ought to have been taken before this tribunal.
Then your lordship may pass an order that I can approach the tribunal today.
Of course. That you are entitled to. You don't require an order.
That unless you makes an observation, that
All right.
authority may say, I don't have any power to review my own order.
You show us the act, whether the power is there or not. Really?
Only that observation, my lord, that I may be allowed to withdraw and approve the, my lord.
Heard Mr. M.K. Chaudhary, learned senior counsel, assisted by Mr. M. Dr. The learned counsel appearing for the petitioner, Mr. H. Bora appearing for GMDA.
That's 101.
Respondent number 1. This writ petition is directed against the order dated 13th November 2024, passed in Riyadh/Assam/appeal number 20 of 2024. Stop. The case projected before this court by the petitioner is that the petitioner is the owner of a apartment situated in the ground floor of a construction undertaken by the appellant before the RIAT, namely Messrs. Supriya Construction, who is therein as respondent number 2. So, the said apartment is in the building under the name and style within brackets Supriya Residency, located at village Atigaon, Moza Beltola, Dispur, Guwahati. So, it is submitted on behalf of the petitioner that the petitioner, although had occupied the said apartment after due payment of the consideration. When did you occupy it?
My lord, the registered sale deed is, my lord, page 46, 1/4/2020.
1/4/2022.
My lord. But he was, my lord, given possession prior to that. In
1/4/2022. However, the occupancy certificate, which was required to be granted to the petitioner, to the appellant, was not issued by the GMDA.
By the GMDA, because, my lord, they did not file a joint application.
As the builder
and the landowner
declined to put, as the landowner declined to put his signature in the application for the occupancy certificate until the deviations in the construction of the real estate project are duly rectified. So, Learned Senior Counsel for the petitioner submits that the deviation in the construction pertains to the ground floor relating to the parking area. So, in the as the occupancy certificate was not issued, the petitioner filed a complaint before the
RERA,
Real Estate Regulatory Authority. Stop. What was the order passed? What was the order passed? Imposition of fine.
Imposition of fine. Well, that is not in my application. My lord, the application filed by the, my lord, builder.
Before the RERA. What happened to your application?
My application have been tagged together, my lord.
My application said that GMDA can proceed, but there is no directive.
GMDA can proceed, my lord. That has been observed in my petition. There is no directive.
Proceed what? Proceed for?
Proceed, my lord. In fact, my lord, the proceed is also, my lord, demolition as per law.
Subsequently,
that your lordship finds at page 123.
A similar application was also filed by the builder, namely respondent number 2. So, where is that order?
Page 123.
The RERA by order dated 2/7/2024.
It starts at 123. Operative part, your lordship, my lord, finds at 120.
Impose a fine of
124.
Impose the fine of rupees 2 lakhs.
124, last paragraph.
$126, I think.
That is, my lord, with regard to builder's application. So for my application is concerned, my lord, page 124 at the end, my lord, last paragraph. As such, the respondent number 1, Supriya Construction, represented by so and the two partners so are directed to submit their response before the next date of hearing without fail. So far as the violation of norms of GMD, GMC in connection with the building is concerned, the GMD, GMC authorities are free to exercise their own jurisdiction and powers as per law, and this authority has not passed any order prohibiting.
The RERA by the said order permitted the builder to file their response to the application filed by the petition, present appellant. And insofar as the application filed by the builder is concerned, the penalty of rupees 2 lakhs a continuous violation was imposed on the said builder, namely Supriya Construction. So, being agreed, the construction respondent number 2 prepared an appeal before the RIET, being RIET Assam appeal number 20 of 2024. So, by order dated 13 November 2024, the RIET while directing the appeal to be listed on 12/12/2024. The respondent number 3 before the RIET, namely the GMDA, was directed to carry out necessary exercise in terms of its direction contained in the letter dated 29/9/2023, so as to end the stalemate involving the initiation of due process for grant of occupancy certificate. So, it was further directed that any date fixed for carrying out a demolition exercise by the GMDA shall be intimated in advance to the appellant as well as to the respondent number 1. So, whereas in terms of this order, by notice, by order dated 6/12/2024, the GMDA intimated the respondent number 2
and 3.
2 and 3 about the proposed demolition of the violated portion of G+3 building. Is it the same building? Building of Ananta Dev Sharma?
Yes.
Building of Ananta Dev Sharma
He is the owner
near
of the
Prabhas Atiti Griha, Bokhistapur, Island number 2, Beltola, Bokhisto Road. Stop. The demolition is scheduled on 11/12/2024 from 10 a.m. So, the Para-learned Senior Counsel submits that a copy of this order and notice was served on the appellant by the builder. By the stop. The grievance of the appellant before the court is that while there is no grievance with regard to the imposition of penalty on the builder, namely respondent 2 and 3, the direction of the RIET to carry out the demolition by the GMDA will seriously prejudice the interests of the present appellant, as the ground floor portion, which is stated to have been violated, which is stated to be in violation of the original building plan, has been purchased by the appellant and is presently used as her residential
office.
Used as an office. Used as an office. So, under such circumstance, the appellant is before the court. Mr. S. Bora, hearing for the GMD, submit that RIET ought to have been made a party, and there is a standing counsel to the best of his knowledge, who represents the RIET. So, insofar as the proposed demolition is concerned, he submits that this is in terms of the RIET order. Therefore, as notified, the demolition is scheduled to be carried out tomorrow from 10 a.m.
Possible also, my another submission is page 153. Direction of the appellate authority to comply with the order and submit a report.
And as the appellate authority, as the RIET, directed the GMDA to comply with the order and submit a report. Stop.
And bring it on record. The report and
Better. Learned counsel for the parties have been heard. The writ petition and its enclosures have been carefully perused. On careful perusal of the papers before this court, it is seen that in the appeal, which is preferred before the REACT by the
Builder respondent number 2.
builder respondent number 2 being appeal number so and so. The present appellant is shown as respondent number 2. Stop. There is no pleading. It is not, there is no specific pleading in the writ petition as to why the petitioner did not project its case before the REACT when the order impugned the present writ proceeding was passed on 13th November 2024. And the writ petition was filed only on yesterday.
Yes, ma'am. Yesterday.
Was filed only on 9th, which is 2 days before the proposed date of demolition as directed by the REACT. Stop. The senior counsel, hearing for the petitioner, fairly submits that he has no instructions in the matter. Stop. Careful perusal of the impugned order reveals that there is already an order of the GMDA whereby the deviations were required to be removed or demolished as was informed by its communication to the builder. Stop. The question before the REACT was one of the questions before the REACT was also the non-issuance of the occupancy certificate, which was raised before the RERA by the writ petition. Stop. The finding of the REACT is that the non-occupancy certificate not being issued was on the ground of the landowner refusing to put in a joint signature till the builder removes the deviation as per the approved plan. So, under such circumstances, by the order impugned in the present writ petition, direction was issued to carry out the demolition by the GMDA, file a compliance report. The appeal is fixed on 12/12/2024. Stop. There is no explanation before the court as to why the appellant, the writ petition before the court, although having been arrayed as a party respondent in the appeal filed by the respondent number 2 and before the REACT.
My submission
Notes.
recorded that I was not aggrieved by that penalty. That's why I think.
No averment as to why the petitioner, as to whether the petitioner appeared before the REACT and presented its case. So, then a senior counsel, in response to the query put by the court, submitted that the appeal was against the imposition of fine by the builder, and therefore he was essentially not affected by the order of the RERA imposing an appeal of 2 lakhs. So, be it as it may, the fact remains that the petitioner was arrayed as a party. There is no averment that no notice was issued by the RERA before REACT before issuance of the appeal order. There is no explanation as to why the petitioner could not or did not present its case before the REACT before the order dated 13 November 2024 was issued. Stop. There is also no explanation as to why the order dated 13 November 2022 as to why the order dated 13 November 2024 is being put to challenge by the present proceeding, which was filed only on 9/12, challenging the proposed demolition, stated to be undertaken tomorrow, which is 11/12/2024, in terms of the order dated 6/12/2024 issued by the GMP. Stop. In the absence of such pleaded and specific facts. In absence of such specific facts pleaded before this court, this court is disinclined to entertain the writ petition in the present form. So, however, considering the hardship projected by the petitioner in the event the demolition is undertaken in respect of the apartment which the petitioner claims to have purchased from the respondent number 2 and 3, we permit the petitioner to approach the RIET for modification or recall of the order which is impugned. So, the petitioner may approach the RIET immediately as submitted.
I'll be requiring the order, copy of the
Yes,
order.
yes, you get a copy of the order. In view of the urgency expressed, certified copy of this order, a true copy of this order shall be issued by the court master of this court, with the signature of the court master, which may be treated to be an order, certified copy of an order to be filed before the RIET.
Yeah, like,
Disposed. It order mari dibuat. Thank you.
May I please?
Yes.
Are not able to, my learned friend, directly to
Yes, what do you say?
Yes.
Yes. So only 7 lakhs vote is required.
Yes.
Now, what is your submission in respect of the fact that you have resorted to issuance of a warrant?
Yes, sir.
As the first option?
Yes.
What is your submission in that regard? Provident Party.
Yes, Lordship. 8B, Lordship. 8B.
8.
B, Lordship. Section. Defense of certificate the recovery officer. Page 25.
Yes.
Attachment of the sale of the immobile property of the establishment, or as the case may be, the employer. Arrest of the employer and his detention imprisonment.
That is number B.
Yes, Lordship.
So the judgment of the High Court which are placed is
Yes,
that
sir.
ordinarily you should go step by step.
Yes.
So first you should resort to A.
Yes, sir.
Attachment of the property.
Yes.
Then, have you gone through the judgment?
No, sir.
Huh?
No, sir.
You have not gone through.
No.
Why? They were placed before the court
Yes.
on the last hearing.
Yes, sir. Yes. I heard, sir.
Do you want an order from the court to direct you to go through the judgment? You have gone through the judgment. You go through it and tell us at the second half whether your case is in similar footing or you want to argue something else.
No, no.
Yes, Mr. Talukdar. You are for the
Lord, I am for the department. Essentially, in this case, my lord, I have nothing to say.
Because if the
So,
petitioner and
now, who is going to pay the 7 lakh?
my lord,
It has to be there by the department.
in fact, my lord, what I'm trying to say, my lord, this is a case challenging, my lord, the warrant of arrest. So keeping alive this issue, my lord, between the Provident Fund and the society, Lordship will, my lord, in fact, adjudicate this matter, whether the warrant of arrest, my lord, is,
Society has been dissolved.
yes. They have other means in terms of the act, my lord, Provident Fund Act.
Society.
Dissolve question.
That is what we want to know.
Dissolve.
Yes.
Well, perhaps there is an MD by appointing by the from the state government.
There is a
Uh, my lord, MD is still there, my lord, in a poll. Though it is not in functional mode, but since there are huge asset, my lord, to look
Yeah,
after
Mr.
all.
Talukdar, please give us the correct position. What is happening? Has it been wound up, not wound up?
Lordship, may I suggest? I am the retired person.
Huh?
I am retired person. Lordship may entertain this warrant of arrest, keeping alive the issue between the
Keep the issue alive. Keep the issue alive.
recovery issue, my lord.
I know. The question is be to who is from whom is this to be recovered?
Because
There is no running away from the
Lordship,
fact that it is due. There is no running away from the fact that you are entitled to pay the dues.
if I
You are not
Lordship,
questioning the dues.
if I submit a file an additional affidavit, if Lordship go by this my affidavit, is a certificate issued by the MD at a relevant time. Lord, that certificate is issued on 4/5/2019, my lord. There's the
Page number?
Page 11 of my additional affidavit, my lord.
Yes.
File on 2/2/2021. My lord, that due is because of non-submission of some information by the employee, my lord. This is the certificate, my lord. As some of the casual employees have not submitted documents for generating universal account number,
Who now represents the organization?
Lordship.
Mr. Talukdar, I think you have to get the instructions.
Yes,
What
my
is the
lord, in
status?
fact, recently, my lord, 15 days back, a decision has been taken, my lord, to liquidate, my lord, the bank, Escart Bank.
Escart Bank.
Yes.
This is Apple.
Apple. Oh, the Apple. Yes, Apple, I will, my lord, I don't have that instruction. I will.
You get the
Yes,
instruction.
yes. That instruction would be necessary.
More particularly instructions with regard to page number 11 of the additional affidavit.
My lord.
That position is already admitted, my lord, by this communication to placed by my.
We will keep it on 17th. You give us this instruction. 17th December.
That will because you observe, my lord, the instructions required to you.
Heard learned counsel for the parties. This matter was heard at some length. The issue before this court, the issue before this court is the warrant of arrest issued by Provident Fund Authority in respect of the writ petitioner, who was the former chairman, MD of Assam Polyester Cooperative Society within short Apple. In order to enable this court to decide this issue, the status of the cooperative society and its dues presently outstanding and obligor payable to the Provident Fund Authority are required to be placed before the board. So accordingly, we permit Mr. S.K. Talukdar, Study Council Cooperation Department, to obtain this specific information and place it before the court for the next date fixed. Placed again on 17th December.
Fine.
Mr. Detail appears for the Provident Fund Authority and Mr. M. Monroe for the petition. Yes.
May it please your lordship. Lordship, this is a matter wherein I had applied for certain information, which was a political department, my lord.
You had applied for?
Right.
You had applied for?
Certain information.
Okay.
Under the RTI Act.
Yeah.
Well, my lord, firstly, I had applied for information on 6/1/2020, my lord. This is Annexure A, my lord. Now, after the lapse of 30 days, I was not provided the information. As such, I preferred an first appeal. And during the pendency of that first appeal, my lord, certain vague and irrelevant information was provided. As such, I preferred second appeal, my lord, to the concerned authority. But there was a delay, my lord. Now, the delay was not considered, and my second appeal was dismissed.
RTI. State road. Yes. Where is that order?
Order is at page 19, my lord, Annexure G, my lord.
Yes.
With reference to the above, I am directed to inform you that your prayer stating ground for condonation of delay for second appeal is not found satisfactory. As such, your second appeal could not be admitted. My lord, the ground was that it was during the peak of the coronavirus, my lord. And certain exemptions were also there regarding the limitation, which was.
Where is your application for?
Page 16, Lord.
Page 16, before the second appellate authority.
Yes, my lord. Along with the second appeal.
What is the time limit specified?
Second appeal, my lord, it's 90 days.
Where do you find it?
Section 19, my lord.
19.
Yes. Subclause 3, my lord.
Yes.
A second appeal against the decision under subsection 1 shall lie within 90 days from the date which the decision should have been made or was actually received with the Central Information Commission as the State Information Commission. Now, my lord, I had received the information on 7th of March 2020, my lord. Annexure C, page 14.
Yes, well.
My lord, along with the second appeal, I had filed a delay condonation, prayer. I had prayed for condonation of the delay, my lord. But that was not considered.
Do you have that order of the apex court?
Yes, my lord.
Apparently, the period was during the coronavirus. The order was not correct. So we concede to that, but Lordship may send it back for by condoning the delay.
When was the order passed? First appellate authority? You are challenging the communication dated 30th of January.
No, my lord, just the condonation order, my lord.
Before the second appellate authority, what
Yes.
were you challenging?
Actually, what happened, my lord, the first appeal was pending, and then the concerned authority, my lord, they provided the information of 30th of January.
Yes.
As
Then,
such, against that, we preferred a second appeal.
so 90 days from 30th of January.
Yes, my lord. My lord, but this is the information which was inter-departmental. It was provided to me on 7th of March 2020, my lord. Annexure C, page 14. It was forwarded to me.
You received it on 7th of March.
Yes.
So when did you prepare your appeal?
Second appeal was preferred on, my lord, 15/2/2021. Due to the coronavirus, I was not able to approach the authority.
We heard alternate counsels for the parties. This writ petition is directed against the order dated 16/3/2021, passed by the Assam Information Commission in the second appeal, preferred by the petitioner. Stop. By the said order, the second appeal found preferred by the petitioner was dismissed on the ground of limitation. Stop. The learned counsel for the petitioner submits that he had filed an application before the Public Information Officer, Political and Cabinet Cell Department, dated 6/1/2020, requesting for some information under the Right to Information Act 2005. So, since this information was not forthcoming, petitioner filed a first appeal under Section 19 of the Right to Information Act 2005. Stop. The first appeal was filed on 17/2/2020. During the pendency of the first appeal, the information which he had earlier sought for under his RTI application dated 6/1/2020 was furnished to the petition. So, this information was furnished by the department on 7th March 2020. So, being dissatisfied with the information provided, the petitioner preferred second appeal on 15/2/2021, along with an application for seeking condonation of delay filed on the same date. So, learned counsel for the petitioner submits that under Section 19, one, the first appeal may be filed by a person aggrieved seeking information from the concerned authority within a period of 30 days. Stop. Under Section 19(3), the second appeal may be preferred before the Central Information Commission or the State Information Commission within a further period of 90 days from the date when the decision should have been made or actually received. Stop. However, the Commission may admit any appeal even upon the expiry of 90 days if it is satisfied that the petitioner was prevented by sufficient cause. So, Learned Counsel for the petition has submitted before the court that because of the COVID pandemic 19 situation, which was prevailing throughout the country at the relevant point in time, the petitioner could not file his second appeal immediately within a period of 30 days from the date he was informed, from the date he was served with the information by letter dated 7th of March 2020. The appeal along with the condonation petition was filed on 15/2/2021. So it is submitted that the Commission rejected the second appeal filed on the ground of limitation without taking into consideration the orders passed by the apex court in miscellaneous application number so and so by order dated 10/1/2022. So he submits that since the apex court had already extended the period of limitation because of the COVID pandemic situation, the tribunal, the Commission ought to have taken note of this extended period of limitation and considered the second appeal filed by the petitioner and ought not to have dismissed the same on the ground of limitation. Error. Mr. D. Decker, Learned Counsel appearing for the Commission of the respondent, fairly submits that the order passed by the apex court was the order passed by the apex court had extended the period of limitation, and perhaps that ought to have been considered by the second appellate authority. Having heard counsels for the party, the number here located of the local of the court. This court is of the view that the issue involved in the writ petition is within a short compass. So the order passed by the apex court in misapplication number 21 of 2022 in so and so by order dated 10/1/2022 reflects that certain directives were passed by the apex court whereby the period of limitation was extended from 15/3/2020 till 28/2/2022 in view of the then prevailing COVID pandemic situation. So, if this order, by this order, since the limitation period was extended up to 28/2/2022, the application second appeal along with the condonation which was filed on 15/2/2021 was within the extended period of limitation, and the Commission ought to have taken note of the said order and ought not to have rejected the appeal on the ground of limitation. So, for the purposes of the present proceeding, it is necessary to extract the order dated 10/1/2022. Extract this order. So, error. Having noted the directions of the apex court passed in the order dated so and so, this court is of the view that the writ petition should be allowed, and the same writ petition should be allowed. So, accordingly, this writ petition is allowed, interfering with the order dated 16/3/2021. Stop. The said order is set aside and quashed. Set aside. Stop. the matter is remanded back to the second appellate authority, namely the Assam Information Commission, to redecide the application, second appeal, filed on 15/2/2021, along with the condonation petition, by taking into consideration the directions of the apex court passed in misapplication number so and so by the order dated 10/1/2022, and thereafter pass appropriate order in the matter. Stop. With the above observation, writ petition stand allowed, disposed of.
Obliged.
They were supposed to file.
Lordship, I need some time, my lord.
You get your instructions. Your colleague was there, Otila.
Lordship, my lord, that one instruction they said there, my lord, was directed us to, my lord, they pay for some time, lord.
How
Some
much time?
process is going on.
How much time?
So they take, my lord, the 6 weeks time.
6 time.
But if some process is going on, my lord, it will take time.
It's clean order.
Lordship.
We'll grant them 4 weeks time.
That may be recorded, my lord. They are saying that processing is going on.
Yes.
That may be recorded.
Third MS D.D. Roy, learned counsel for the petitioner, Mr. J. Hendrick, learned government advocate, appearing for response 1 with 3. By the earlier order, dated 2/12/2024, the respondents were directed to complete their instructions. Now, today, when the matter is called up, Mr. Hendrick, learned government advocate, submits that further 6 weeks' time is required to complete his instructions and praise accordingly. So, considering that the petitioner is aggrieved by non-receipt of the award or non-receipt of the award of compensation, which was ordered by the MSCP number 1 Kapruk Metro on 11/3/2016. The court grants further 4 weeks time. In view of the submission made by the learned government advocate that steps are being taken to process the same.
Some communication is going on.
No, you said it is under process.
That process means that communication is going on. They have written to the
All right, then you write.
the political and home department
is awaiting instructions. So, on the next date fixed, the respondent government will apprise the court as to the status of the release of the award, compensation amount to the writ petitioner. List the matter again on 20 January 20.
Item 5 and 6.
Yes.
This is a serious issue, my lord, regarding, my lord, the Assam Mala road project initiated in the Dima South district. And these petitioners, before your lordship, are the aggrieved person, my lord. The issue, my lord, is confined to, my lord, that they have shown the notification whereby the lands were being taken by way of a direct purchase. But the process adopted by them is contrary to the notification. That is, the entire process has been, they have done it without following any statutory provision. And from January, my lord, 2024, my lord, they have rampantly, my lord, taking up the land without paying anything, my lord, or without.
They are taking up the
land of these affected villagers, my lord, for the road project, my lord. Now, your lordship will come to the the list of the petitioners affected villagers I have annexed, my lord, page 48, my lord.
Hmm.
Page 48 was the list of the affected persons whose lands have been acquired by them, but without following the direct purchase method, my lord. Now your lordship will come to page 60, my lord. 60, my lord.
60.
Yes, ma'am.
Yes.
From the information, my lord, these villagers, my lord, they came to know paragraph number, serial number 2, my lord, sub-para, my lord, from the PWD department that regarding the list of beneficiaries in village-wise whose lands are acquired for construction of Samala Road project is not available with the undersigned, as the list of beneficiaries has been prepared by the Revenue Department on NC Hills Autonomous Council. Now this thing has been done by them, my lord, without making any verification with the PWD department. So your lordship, they could not provide this, my lord. Now, your lordship, I will come to the relevant issue, my lord. Page 62 onwards are those land documents and the NOC issued to the affected villagers. So this can be skipped off, my lord, from page 62 to page 184. These are only to show that these persons are in possession. Now your lordship will kindly come that several representation were filed before the page 192 onwards, before the PWD also, then page 193 to the Deputy Commissioner, then page 194 to the Principal Secretary from time to time, my lord, initiating from the year 2020. Now, nothing has been done by them by adopting that direct purchase method. But surprisingly,
No, but
lordship,
there is a statement, there is an averment in the affidavit filed with the Revenue Department that they have released huge amount of money to the beneficiary.
they have released, my lord, that was the issue, my lord, that they have released the money. Out of that 66 are they themselves, my lord. The NCA, they themselves has taken the money. They are the sanctioning authority and they are the beneficiaries also. That I will come, my lord. And the genuine person, my lord, who are affected, your lordship will see not a single direct purchase method adopted. I am coming to that statutory provision, my lord. Before that, your lordship will kindly see that page 209 of my
And
repetition.
who are the petitioners before this court?
These petitioners, my lord, as per annexure, page 25, your lordship will find the list of petitioners.
They are the landowners.
Yes, they are affected, my lord. Page 25.
Yes, and what is the stand of the department in respect of the writ petitioner's claim?
Lordship, first of all, this writ petition, earlier they have filed a PIL. Now the Honorable Chief Justice has converted this PIL into writ petition.
Not converted, directed to be listed.
Directed to be listed, Lordship. Since they have concealed some fact, the main fact is petitioners, all the maximum of the petitioners have earlier approached this Honorable Court for relief. Means they are the affected person, their land has been enclosed by the NC, and accordingly single judge has passed some orders. But in the PIL, they have suppressed them, and they have stated that they have not filed any petition. Moreover, the age of the petitioners are also disputed, Lordship.
Yeah,
age. Because Lordship, why I am telling the age? Because PIL petitioner number 1, PIL in WPC, this one, his age is stated as 46. In age 2024.
No, now their claim is that they have not received the compensation amount.
Moreover, Lordship, I would just like to point.
Have you made any averments in the affidavit to
Yes,
say
Lordship,
that
we
they are
have.
not entitled?
Lordship, we have. Lordship, moreover, Lordship, since this is a 6 schedule area, Lordship, in all the petitions what they have filed,
they have stated one thing, that judicial inquiry should be there. Judicial inquiry. They, and without approaching for means in what I am stating from part 3 of the this one filing of PL, it has been clearly stated in paragraph 6 that in paragraph 6 of the writ petition, details of the representation made to the authorities concerned for remedial actions and replies, if any, received thereto, shall be set out precisely. They have not stated anything whether they have approached any other authority. And moreover, Lordship,
For what purpose?
for judicial inquiry, for initiating, because they cannot approach the Honorable High Court at the first instance for judicial inquiry. They have to approach the Honorable Governor, Lordship. He is the head of the 6th schedule area, Lordship. If Lordship comes to
Now, first tell her what, whether the petitioners are entitled to the benefits of compensation or not.
Lordship, we have already stated in our affidavit, Lordship, that we have already paid them the compensation amount. Only the land development.
You said you have paid to the landowner.
Yes, Lordship.
So whether the petitioners have been paid or not, or are they entitled to be benefited or not?
Some of them we have paid.
No, not like that. Even there are not too many petitioners. How many
Yes, Lordship,
petitioners?
there are.
Page 25, around 200.
There are 9 petitioners.
No, Lordship, one is 9 and other one.
Page 25 are the affected person. These are 200 money.
So give us the list. Tell us whether these people are landowners. If they're landowners, whether they have been paid, not paid.
Lordship, we have already stated in our affidavit, Lordship.
Your affidavit statement is omnibus. We want specific detail.
Lordship.
Because you know the persons who have come before the court. They are saying that they are landowners.
They are landowners, Lordship.
Now, whether they're landowners or whether their money has been paid, not paid, you have to satisfy us.
Lordship, we will, Lordship, we will. But Lordship, first thing is that, Lordship, this petition is not maintainable, Lordship. This petition is not maintainable. In the matters of judicial, they have asked for a judicial inquiry, Lordship.
Forget their prayer. We are asking you a query. You satisfy us.
Yes, Lordship, we will, Lordship, we will. We will, Lordship. Lordship, this is the Lordship, this one is PIL 5. 5 is different. Yes, Lordship. PIL 5 to WPC number. Proton to the Lordship.
There an affidavit is before us, filed by respondent number 9.
Lordship.
Who is the secretary and revenue officer.
Lordship.
Para 7, there is an averment of payment of 66 crores 88 lakh 70,943.
Yes, Lordship.
As compensation.
Yes, Lordship.
Sorry, compensation is 63 51 069. Disbursed to the affected land.
Yes, Lordship.
Whether the petitioners fall into that category or not.
Some of them, Lordship, not all. That we have annexed the list also. The list is annexed 2, Lord. The use list, Lordship.
Now, if those who have been excluded, why have they been excluded?
Because their land have not been taken, Lordship.
Where have you stated that? That averment is not there. That averment, that these, out of these 100, 200 people, X number are landowners, they have been paid, Y numbers are not landowners, they are not paid. Where is that averment?
Okay, this is huge bunch of these, Lordship. So I have to.
You filed by you only.
Yes, Lordship, we have. So I need some time.
We did not impose it. You filed this use, but
yes.
And now you are complaining it is
No, I am not complaining. Lordship, I need some time,
My Lord,
so that I can clear your Lordship.
May I submit, my Lord, one thing? Lordship will come to their paragraph 6 of their affidavit.
7.
Paragraph 6, my.
Yes, 6.
Your Lordship will kindly see district level land purchase committee. They have formed one committee, my Lord. And secretary revenue is serial number 8, my. Now, district land for
He is the member secretary.
Yes. Lordship will find a court line that it was done as per Government of Assam notification. I have placed the notification, your Lordship will kindly see. They have flouted entire guidelines, your Lordship.
Now
That
this
is
is
the-
not, this is no longer a PIL.
Yes.
So you have to be very specific about your prayers.
Yes, my lord. Now, I am, my prayer that
Your
they have,
grievance would be that you have, your land has been taken, but you have not been given the compensation.
Yes. Now, in case, my lord, if land are taken by direct person method, then the mood is, my lord, they have to take by negotiated settlement
Hmm.
by way of an agreement. Your lordship will find clause 4, my lord. In similar case also, our Honorable High Court has passed order them to reconstitute the committee, my lord. Your lordship will find clause 4.1. I also placed type copy. Here, your lordship is step 1. The requisition department PWRD shall finalize the minimum extent of land required for each road project under Assam Malayan externally aided project EAP. The requisitioning agency shall give the requisition to concerned deputy commissioner. Now here deputy commissioner is excluded, madam. Now second, your lordship will see 4.2. The district level land purchase committee under chairmanship of concerned DC is to be constituted for direct purchase of land as well as fixation of market value, my lord, etc. The DLPC will be constituted of following concerned persons: district deputy commissioner, chairman. Then these are the person, my lord. Next page, my lord. Executive engineer, PWRD member. Then revenue circle officer member. Now your lordship will kindly see what has step they have to follow. Step 3, my lord. Concerned revenue circle officer, concerned revenue engineer
No,
of
no.
PW.
Firstly, is it by direct purchase method?
Yes, my lord. They have
Lordship,
admitted. They have admitted.
We
Where,
have
where,
constituted a committee, and
That
that
is the
committee
case.
has been constituted as per Assam Gazette notification. Now my learned friend is objecting the Gazette notification.
No, no,
Lordship.
I'm
That
not
we have
objecting.
stated, Lordship,
They
in
have not
paragraph
followed.
6.
Para 6.
Yes, Lordship. That the deponent begs to
Gazette
state that
notification.
running page 310.
No, this is a different Gazette notification.
No, this one, Lordship. This Dima Hassan Autonomous Council has constituted a district level land purchase committee in pursuance of Government of Assam Gazette notification number so and so dated Haplong
Same, my lord.
21st. This
How
Lord.
can it be same?
My lord, they have wrongly quoted this. Your lordship will see the notification number is same, and this is also followed in all other cases also, my lord. They have wrongly quoted the date, my lord. That is the thing, my lord. Your lordship will kindly see the notification. This is the notification. That is number DA 5R80 2020 oblique 3 dated 20 January, month. They have quoted at 20 at 1 month. And they are themselves, they have stated that they are bound by this notification. And the steps taken in that notification, none of them they have flouted all the norms.
The number appears to be the same,
Yes,
but the date is different.
this is to, my lord, create confusion, my lord.
I am also.
Now our case is there.
Let it come up on Thursday, Lordship. I will certify your Lordship. As your Lordship.
My lord, the thing is that yesterday also they are doing it, my lord, forcibly evicting the person. And other lands.
Thursday,
also.
coming Thursday.
Yes, Lord.
All
Day
right.
after.
Day after. Let us have it on day after. Let
My
them
lord.
get their instructions. Matter be listed at the request of Mr. R.M. Deka, Counsel for the Dima Assam, Standing Counsel.
R.M. Das.
State paper to be
Das.
R.M. Das. Matters state paper to be listed on Thursday, which is 12.
Well, as
Mr.
pardon,
P.
my
Bhuva.
lord.
It will come.
Because, my lord, they take time, my lord. Last occasion, they take time.
All right.
That is the thing, my lord. Every time they want to, my lord, bypass the issue, my lord.
We will not grant you time on
No, no.
Thursday.
No question of
Last time, my learned friend was absent, my lord. That's why. Last occasion, your lordship tried to dispose of it. Obliged.
Thursday.
Thursday.
Yes.
12. Arbitration act. So far as this item 7 is, what is this item? 7.
My lord.
There appears to be, there is a notice by the party authority. Yes, what is your submission with regard to the notice?
Here, the language used in the section 21 is not by party, is by is language is respondent. And the judgment cited by my learned friend related to the serving of award to the party.
No, but there is an argument raised by him.
Yes.
That everywhere in the act,
yes,
the party reference, the whole act is between two parties.
Party.
So every section has to be understood to be by or for the party.
That is not the correct position, Lordship. Already on the last occasion, I have submitted a judgment passed by this honorable court, wherein
Here, this argument is not reflected. This argument raised by my learned, by your adversary.
yes, reflected, Lordship.
Where?
Yeah, I'm Lordship. Come to paragraph number 3, Lordship.
The Payus trader.
Yes, Lordship.
Payus trader.
Yes, Lordship.
Yes.
One,
Yes.
no. Paragraph. Eight has been defined. Page 3, last Roman 4. Paragraph number 7, subparagraph Roman 4. The notice seeking arbitration was issued by the advocate on behalf of the party, and the expression party as defined in the Act 1996 means a party to the agreement, and such definition is not qualified in any way so as to include the agent of the party to such agreement. Therefore, the demand of arbitration issued by the advocate of the party cannot be treated as a valid demand of arbitration, and therefore on this count also the present petition is liable to be dismissed. In support of such contention, Mr. Gogoi relies on the decision of the apex court, which my learned friend has relied on. And this finding part is in page 6, Lordship.
There is another way to look into it. There is no quarrel with the fact that there is an agreement.
Yes.
There is also no quarrel that it contains an arbitration agreement.
Yes.
Whether the disputes are to be arbitrable or not arbitrable, according to you, to be decided by the court. According to you, they are not arbitrable. There are several judgments, including a judgment by this court, to say that let's left arbitration tribunal to decide whether it can assume jurisdiction or not. Now, under such circumstance, and also appointment of arbitrator from your panel under section 12, unless it is waived by the contractor, is no longer available to you.
Yes.
So there is no quarrel that there is a dispute.
No.
There is no quarrel that the act contains an arbitration agreement. Recent judgments, including LIC, SBI, life insurance, very has made it clarify the issue that referral court power is only to examine whether it is there or not.
Yes.
And it is there. No. There is no quarrel. There is no quarrel.
But here the issue is not of arbitrability.
No.
My lord, here the issue is
No, we are coming to it. We are coming to your issue. We are coming to your issue for the sole reason is why are we called upon to decide it in the first place?
no.
For the simple reason that even today it is open for you to appoint your arbitrators if you want.
Yes, my lord, they can give a notice, party should give the notice.
No, there's no
We
question
will
of
appoint
notice.
it.
There's no question of notice.
That's why we have not replied it, my lord.
My lord, sorry to interrupt, my lord. They have received the notice. My lord, kindly see the petition. They have referred to my lord, they have referred to our section 21 notice, my lord.
What we want to say is that even during, if you do not dispute the existence of an arbitration agreement,
My lord.
and even if you dispute whether the dispute itself is arbitrable or not, in view of judgments, it is to be left to be decided by the arbitration tribunal.
Yes, yes.
Question now is, in view of this undisputed position of there being an arbitration agreement and there is a dispute, whether you can appoint an arbitrator today during the pendency of the proceeding.
For that, there has to be an invocation.
No, you're already,
Invocation is not
you're
by.
already before the court. It's
Yes.
under
My lord,
11.
under section 11, yes.
You can still appoint an arbitrator.
My lord.
We
Yes,
can
sir.
give you an opportunity to appoint an arbitrator, or you can agree to the suggestion made by the petitioner.
That is the intention of the legislature.
So why should we even go into this controversy of whether 29 needs to be issued by a lawyer or by the party? What for? That position is gone now.
Yes.
And position is gone.
My lord.
That position is required only to give you an opportunity to raise this issue. Number one, there is no arbitration agreement. Number two, there is no dispute.
Yes.
And then prior to Central Railway Organization's matter,
My lord.
you had the option of having your panel of arbitrators. They
That
will
is
have the
gone.
option to select. That is also not there.
Not there.
So under such circumstance, in view of the recent law,
My lord.
why should the court be detained on this question of whether it is to be issued by a party, not by a party? We are not even going into that.
Not here, my lord.
We are giving you an opportunity to appoint, concur on the appointment, or we appoint an arbitrator.
Well,
And Lordship, we have issued the notice on 13/7/2024, but they have not disputed that fact. The notice has to be issued by party, and they otherwise demanded for arbitrator
Which,
as per
according to your adversary, is a question of law. It can be raised.
Yes.
Which perhaps he may be right.
Yes.
But the fact remains that you don't dispute the existence of the arbitration.
that is there, my lord. But what is vital is, my lord, that the invocation
So-
has to be by a party.
No.
They can give a notice today, my lord, we will appoint.
That is not.
No.
Because, my lord, the agreed procedure of appointment is now no more there in terms of the recent Supreme Court judgment.
Exactly.
The party has come under 11/6 now, my lord, when the judgment has come subsequently, my lord. And that party has come, my lord, in view of the earlier agreed procedure.
You're not getting the issue.
Now, 11/6,
You are on the procedural part. The purpose of the procedure is not to prejudice your rights.
So that procedure is now the agreed arbitral procedure is no more in existence. my lord.
Exactly.
Therefore, my lord, section 11(3) will come into play.
No, therefore,
My lord, section.
you are now to agree or
No.
disagree on the arbitrator to be appointed in view of the fact that you are not raising a dispute as to the existence of the arbitration agreement. You cannot raise a dispute that is dispute itself is not arbitrable.
But my lord, the invocation has to be by the party, which to the railway is not bound to reply to, my lord, a person who is not a party to the agreement. That is our basic plea.
So in so far as first case is concerned, there is a first letter
My lord.
bringing it to your notice by the party itself.
Yes. And that letter is also, my lord, by this, the applicant is, my lord, a private limited company. There is no, my lord, will see.
Where is your first notice?
The first notice is by a party under clause 63, my lord. The arbitration notice is at page 110 in item 7, my lord.
Where is that notice, Mr.
President,
Kapoor?
Annexure 6, 21/4/18,
Page number
page number 92.
92. You come to page number 98.
No, Lord.
You come to page number 92 first.
Yes, my lord. Yes, my lord.
This is the notice issued.
This is a notice under clause 63, my lord. This is a pre-arbitral process
No, no, no.
as
No,
contemplated.
come
This
to
is
come
not
to
an
98. Come
My
to
lord.
98. Page number 98.
Yes.
Last para.
Last parameter, we request you to, we request you that our contract should be determined under clause 61 of the GCC and settle our above issues at the earliest in case our request is not considered, we request to appoint arbitrator in terms of clause 64.
That's right.
So therefore, my lord, this application is not in terms of clause 64.
No,
This is
this
an-
application
It
is
is under,
because,
my lord,
no,
in
this
terms of clause
application,
63.
This application is because you have failed to appoint in terms of this.
No, my lord, no, my lord. My lord will take the.
Page 44 of the
My lord, the
agreement.
page 92 annexure 6, my lord will see to whom it is addressed. My lord, it is addressed to the general manager and a railway for settlement of dispute.
This can be raised
And my
for the
lord-
arbitrator.
And my lord, section 60, clause 63, my lord will take page 56. This representation is a part of a pre-arbitral process. My lord, first the representation has to be
Clause,
made.
clause
Clause
63.
63
Huh.
at page 56, my lord. All disputes and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred to by the contractor to the general manager, and my lord, the general manager shall within 120 days after receipt of the contractor's representation make and notify their decision on all the matters referred to by the contractors in writing. Now, this was
Now,
not repli-
what happened? What is your reply after this letter?
This was not replied to, my lord.
Then,
Therefore, under clause 64(1), subsequently, my lord,
yes.
in the event any dispute or difference between the parties hereto, or construction and operation of this contract or respective rights and liabilities within the contract may claim, and if the railway, my lord, fails to make, or if the railway fails to make a decision within 120 days, then and in such case, but in except in any of the accepted matters referred to in clause 63 of the general conditions of the contract, the contractor shall after 120 days, but within 180 days of presenting his claim on the disputed matter shall demand in writing that the dispute or difference shall be referred to arbitration.
We'll read
This
read
demand-
this. We'll read this provision into this notification. What is your difficulty there?
This is
Demand-
this
demand-
demand was made by an advocate, my lord. This
No, no, no.
The requirement
The notice under 63,
that is not an arbitration notice.
you
Under
did not reply to it.
Yes,
You did not reply to
and
it.
if it is not replied, my lord, the demand for arbitration can be made.
We'll read it as a notice for demand for an arbitration because it specifies there.
My lord, under
It
the
specifies.
demand for arbitration can be made only under clause 64. 1(1), my lord. Specifically, the title says, my lord.
Provided 63 is complied with.
No, my lord. 63 is separate, my lord.
63.
Clause 64, 1(1), the demand for arbitration, my lord, we'll see the heading. It starts from there. 63 is a part of a pre-arbitral process.
Yes.
It's a part of a pre-arbitral process, my
That's
lord. And
right.
this representation dated at annexure 6
That's
is a part of a pre-arbitral process.
So
This cannot be
therefore,
treated
that
as an
letter
arbitration
itself,
notice.
that letter itself contained a request to refer it to arbitration. If you,
But
if
that
it
is not an arbitration notice, my lord, as per clause 64.
how are you prejudiced? It has to be judged from from the point of view of prejudice. How are you prejudiced? How are you
Under
prejudiced?
the law, my lord, an arbitration notice has to be sent by a party.
No.
And the railway authorities are not bound to reply to that notice, my lord.
No.
That is my humble submission.
The mandate of this act is to sort out differences.
Yes.
The mandate of this act is not to prescribe a procedure, and in the failure whereof,
But my
the
lord,
entire process or entire scheme of the act should fail. The mandate of the act, you have agreed for arbitration. There was no compulsion for you to agree for arbitration.
no, lord.
Your arbitration agreement clauses are only 64, that's all. There's
No.
no specific detail
No, lord.
elaborately explaining how the arbitration is to be proceeded.
But under the
And
act, my lord, it is.
That's right.
Because
The absence of a specific notice under 21 assuming we accept it, how are you prejudiced? Is it a case that you don't know that there were disputes? Is it a
This
case
is the
that
requirement of the law, my lord. We may not be prejudiced, but my lord, it is the statutory requirement.
you show us that
Because, my lord, I will refer, my
procedural-
lord, to the
procedural
provisions
requirement
of the
the law?
1940 Act for that, my lord. Prior to that, what was the provision? There, my lord, both the parties were there, my lord. And the definition of party, my lord, was brought into force in the year 96 only, 1996 by the amendment, specifically, my lord.
Yes.
My lord, the corresponding section 21 is section 37(3) of the 1940 Act.
Section
37, my lord.
37. Yes.
Subclause 3, my lord.
And then tell us the coordinate bench order, has it been appealed against?
My lord, coordinate bench order, my lord, if I may, my lord, if I may, I will come to it, my lord.
Hmm.
I will come to read this, my lord. Law section 37(3).
Hmm.
For the purpose of this section of the Indian Limitation Act, an arbitration shall be deemed to be commenced when one party to the arbitration agreement serves on the other parties thereto a notice requiring the appointment of an arbitrator, or where the arbitration agreement provides that the reference shall be to a person named or designated in the agreement, requiring that the difference be submitted to the person so named and designated. This section 37(3), my lord, was modified and now has been brought by section 21. And admit that, my lord, it points out to the parties, and therefore, my lord, the parties were specifically
No,
defined.
no,
also.
you tell us, all right, parties, you tell us that by, you see, section 21 does not specify any specific form. Doesn't specify any form. If you are reading section 21,
My lord.
then the rules of interpretation will say that you first understand what section 21 talks about. Section 21 is a request.
Yes.
For the dispute to be referred to arbitration, received by the respondent. So
But that request, my lord, because it starts with the clause, my lord, unless otherwise agreed by the parties. Because, my lord, there are several provisions wherein, my lord, the matters are left with the discretion of the parties, my lord. If I may, my lord, point
no
out,
discretion.
there are many provisions, my lord, regarding the determination of number of arbitrators.
No, maybe we
challenging
are on
termination of-
the issues, we're on the question.
No,
We are on the facts which are not disputed by you.
Yes.
You don't dispute the existence of an arbitration agreement.
Yes, my lord.
You don't dispute that certain differences have appeared. You don't dispute that there was some letter issued by the
No.
contractor which you did not reply.
Yes. But our
only grievance is that it is not by the party concerned, as per your interpretation, sought to be brought in under section 21. Section 21 doesn't talk about parties.
No, section 21
Does not talk about parties.
It talks about parties, my lord, because
doesn't-
you know, it starts with the word unless otherwise agreed by the parties.
Right. But
So, my lord,
it begins on a request for that dispute to be referred to the arbitration received by the respondent.
yes. So, my lord, the words start with unless otherwise agreed by the parties. The arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the arbitration.
That's right.
So, meaning thereby, my lord, if the party agree some other date for the commencement of the arbitral proceeding, my lord, that will be the date. If not, my lord, then it is the notice.
That's right.
That is the invocation, my lord, which starts
Therefore,
the commencement.
In the facts of this item number 7,
My lord.
there is already a notice brought to your notice that
Not by a party. That invocation under clause 64. First letter is, my lord, a pre-arbitral process. That is not an arbitration notice, admittedly under the contract clause.
So we will read that into it for the simple reason you are unable to tell us the prejudice that is likely to cause to the railway.
The prejudice, my lord, would be, my lord,
Your-
that a non-party, my lord, cannot approach.
Who is a non-party?
We are, my lord, technically also, the contract agreement is between the parties, my lord, and the arbitration is arising out of a contract agreement. Now, my lord, we'll see that page 110, this petitioner before lordship is a company, my lord, it's a private limited company. And the authorization, my lord, there has to be an authorization by the board of directors.
No, you show us, you
My
show
lord
us
will
the
take page
agreement,
110
you show us the agreement to the contract.
Yes.
All your communications are to
16.
the petitioner?
Yes, my lord. Page 16, my lord.
Yes.
It's a contract agreement between the, my lord,
Between the company?
between the President Railway Administration called Railway and VK Suit Engineers and Contractor, hereinafter called the contractor.
That's right.
It doesn't include anyone else, my lord.
No, so where, prior to this execution of the agreement,
My lord.
you show us who signed this agreement on behalf of the contractor? Where is that board of directors resolution that he is authorized on the basis of which you entered into a contract?
Well, in fact, board of resolution has to be from the side of the.
But you signed it
My lord.
without even pressing for it. You've got yourself bound by this contract.
My
And now you're turning
So
around.
that
to raise
that
a
would be
question.
there, my lord, that I can produce, definitely, my lord, that will be part of the, at present, my lord, it has not been annexed by them.
You are
but it is-
raised by, this action is raised by you.
Yes. Authorization is there, my lord. Here, my lord, we'll see at page 110. This invocation of arbitration is by the advocate, my lord. My lord will take 110 for a moment, my lord, paragraph 1.
No, you are not answering the questions to the court, of the court.
My lord.
You're not answering.
Regarding that authorization, my lord, I have to.
Not authorization.
My lord.
Why should this first notice at page 92 should not be
Yes.
treated, should not be read as a notice, also under 21?
It cannot be, my lord, because as per the express terms of the contract, my lord, it is clause 64.
Therefore,
Which
therefore, 63 presuppose that you will attempt a resolution of the disputes
My lord,
for which this communication was raised.
that was by party, my lord. That notice was by the party.
Exactly.
Yes, my lord.
What is your response to that notice?
No, that we didn't responded for
Then-
that reason, my lord. They have invoked the arbitration.
So
under
it's not
64.
your case that you had attempted to respond and resolve the disputes. Therefore, this notice cannot be taken as a notice under 21. It's not your stand. You ignored this notice.
No, we ignored this notice because it is
Why?
not by a party, my lord.
Say, no, the first
This
notice,
arbitration
first notice, the
Yes.
first notice.
First notice is, my lord.
And you did not ignore the arbitration notice also because you replied.
My lord.
You replied to that.
No, we did not reply to the notice, arbitration.
There's no reply?
No
The
reply.
arbitration notice?
No reply, no reply.
In your matter, there was.
Yes.
In my letter, there were reply. They have replied thrice.
Yes.
So, my lord, here one part of the pre-arbitral notice is by the parties, but the other party is by the, my lord, by the non-party, and my lord will take page 110. It is a private limited company. And the wordings of the notice, my lord, in fact, this is a legal notice, my lord. It is not a notice, arbitration
Going
notice.
back to your
My lord. And my lord, one thing I
without
just,
answering the queries which are put to you.
the prejudice part, my lord.
You have entered into a contract without verifying whether he is authorized, not authorized. You have signed it. You have bound yourself.
Yes.
In terms of the said contract, you are required to refer to pre-arbitration
My lord.
situation. You did not.
We have not.
You remain silent. There is a request that in case of failure, refer it to arbitration.
Yes, my lord.
Why should it not be treated as 21? Notice, sufficient notice. You are required to be put to notice to that there is a dispute. Please refer it to arbitration.
To that, my lord, my humble submission only would be that it is the requirement of the law that notice has to be by the party. my lord.
Requirement of the law has
That
to
is
be,
very clear, my lord,
that
because
requirement of the law has to be judged on the basis of the purposive intent of the statute. What is the purposive intent? To sort out disputes.
yes, my lord, but my lord will also
to
appreciate.
ensure that parties don't litigate.
But my lord
They
will also
resolve- they
appreciate
decide
one.
on the arbitrators and
My
resolve.
lord, yes.
Your stoic silence and refusal to accept it
My lord will
has forced them to come to this court.
My lord will appreciate one fact, my lord, that the stage of invocation of the arbitral proceeding, it's a very vital stage.
Therefore,
It is not, my lord, commencement of proceeding.
Please explain the prejudice. What is that prejudice? What is that prejudice faced by the railways if this 92 notice is taken as a notice under petition, is read as a notice under petition? What is that prejudice?
Prejudice will be, my lord, that anyone who is not a party to the agreement, my lord, can come before.
Please refer to 21, 92.
Yes.
92 is by the company itself.
My lord.
Ninety-two is by the company itself.
Well, why my humble submission is only, my lord, regarding the, there's a very clear statutory provision, my lord, which party is very categorically defined.
Yes.
And my lord, there is a difference between, my lord, the commencement of arbitration proceedings, my lord, and the, my lord, commencements of proceeding before an arbitrator. There are two different things, my lord, and this is a very vital stage. And the judgment, my lord, which I have referred to, and which has also been discussed in the, my
This
lord,
is with
coordinate bench
this is
judgment.
with regard to the question of limitation arising from the date
Award.
of award.
Yes.
Now the date of award will be on the date the copy is served on the
Party.
Now,
So, my lord,
in that context,
if we apply that principle to the stage of commencement of arbitral proceeding.
No, for what purpose? Where is the limitation?
Because, my lord, if for the purpose of award, a
Purpose of
person
award.
cannot be a non-party. My lord, in the same way for invocation of the arbitration,
That's for the
it cannot be by a
for
non-party.
the arbitral tribunal to decide
No,
whether it is a party to the arbitration or not, or whether a non-party has applied for an arbitration. All these issues will be decided by the arbitral tribunal. You reread the judgment of the apex court to tell us that the scope of the referral court is extremely cutting.
My lord.
Right?
But, my lord, the invocation part, my lord, has jurisdiction.
Sorry?
The part of invocation of the arbitral proceedings, lordship.
How does it prejudice the employee? How does it prejudice?
That situation I cannot contemplate at the moment, my lord, but my
You have
humble
to-
submission to it, my
you
lord,
have-
is
because
that
the
it's a requirement of the law.
The insistence of the procedure
My lord.
cannot be at the cost of waiver of the substantive law, the purpose of the law.
My lord.
If you had consented to the appointment of an arbitrator, this proceeding would not have come to light.
Yes.
It is because of the purported failure of the respondent that this proceeding is before the court.
My lord.
So how does it prejudice your right that it is not in, because there is no form prescribed.
No. But here, if I would like to submit, my lord, that if once the invocation, presuming, my lord, we allow this invocation by a non-party. Tomorrow, my lord, once the award is passed.
You are going back to a
My lord,
non-party
my lord,
because
no, my lord,
we are not insisting on the notice given by the advocate. We are referring to you with regard to this
Earlier, 92, yes, 92, my lord, that, for that, my humble submission is that, my lord, that is not an arbitration notice in terms of the contract clause. Arbitration notice
Therefore,
is, my
you
lord,
have to
clause
explain
64.
prejudice. Therefore, you have to explain the prejudice. How does
No,
it
no.
prejudice? When there is a categorical request to refer it to arbitration in case
No,
of
no, that
failure,
is for adjudication of the disputes.
and in failure refer it to arbitration.
Yes, that is subsequently.
To which
Yes.
you did not respond. You did not respond to this notice. You don't deny receipt of that notice. So where is your prejudice?
For that, my lord, my humble submission would only be, my lord, that the manner of appointment or the manner of raising the demand for arbitration should be as per the contract agreement,
Subject
which is
to
clause
your-
64.
Subject to your explanation that the hardship or the prejudice caused to you. We'll accept it. You tell us that this is the prejudice faced by the railway because if this is not followed.
So that is the
Ultimately,
Malord,
it has to be
requirement of
tested on the touchstone of prejudice. How are you
prejudice, Malord. Presuming, Malord, that if this notice is allowed today, that a party, a non-party, a lawyer who is not authorized, here, Malord, it's a private limited company, there is no board resolution authorizing the lawyer.
You signed it? You signed the agreement?
No, Malord, I am talking about the arbitration notice, which has been sent.
We are not dealing with the arbitration notice.
No,
We are asking you to give us a reply on this
92 letter.
92. And why would it be treated as sufficient notice under section 21?
Because, my lord, that is not a notice admittedly, my lord, because as per the contract clause, it is clause 64, my lord, by which the demand for arbitration
That
has to be
argument is
raised.
already made.
And this is, my lord, a pre-arbitral process under the contract. my lord.
You have not taken steps for the pre-arbitral solution of the
That's why, my lord, it has come to a situation of 64. But that 64, my lord, we are submitting that it ought to have been by a party. By the parties to the
This is a very technical objection to ensure that there is
No, my lord,
arbitration.
tomorrow, my lord, if it is allowed, my lord, today, then, my lord, a situation may arise that the arbitral award may also be communicated to the advocate, my lord, who has initiated, who has invoked the arbitration proceeding.
The prospect of any mischief being committed.
Not mischief, my lord, I am talking about
We are talking about a mischief or a shortfall or a mistake being committed by an authority shall not be a ground to not to invoke the mandate of this statute. Whether how the arbitral tribunal serves a copy is left to the arbitral tribunal to decide. It's not
Exactly.
The invocation is allowed today.
Yes.
Invocation of the proceedings, arbitral proceedings is allowed by a non-party. He
In
becomes
fact,
a party of the
Why do
proceedings.
you say non-party?
My lord.
Why do you say it is a non-party? Why do you say it is a non-party?
The letter is, my lord, by the council, by a non-party. Admittedly.
You are skirting the questions put by the court.
My lord.
We are asking you to give us a reply on 92 to 98.
92, my lord,
Why this interpretation shall not be accepted that this is sufficient notice under 21? And it is by the contractor.
That, my lord, I have already submitted, my lord, that is not a notice under 21 as required in the contract. That is a, my lord, pre-arbitral process. And, my lord, it is only clause 64 under which the demand can be raised.
Do you have a suggestion for appointment of an arbitrator?
At the moment, if any one of our retired lordships are there,
All right. We'll pick up a name from the list.
Milos. We have no objection.
We'll pass orders and this is subject to the prospective arbitrator giving a written disclosure under 12. So we are not closing the matter. We are keeping it for presentation, placing before us the disclosure. But this is only in respect of your matter. Insofar as the other three matters are concerned,
Yes.
you have to address the court.
Yes, I will certainly, my lord. Your lordship
Yes.
now kindly permit me to address my matters.
My lord, may I leave?
Yes. Yes.
My lord, there is a distinction in the, there is a
My
distinction.
learned friend starts, but may I point out, my lord, regarding the very application which has been filed, my lord, this is the application filed by the joint JV, GRJV, my lord, joint venture. The joint venture, my lord, comprises of two private limited companies. And, my lord, the private limited companies, there is no authorization letter. The person who has sworn the affidavit, my lord, he has simply said he has been authorized. There is no board resolution authorizing him to file this application under section 11. These are two private limited companies, my lord, making a joint venture. And now this section 11(6) has been filed. Although it has stated that in page 3, paragraph 2, that he has been duly authorized by the applicant joint venture, but there is no such authorization in the form of board resolution, etc. So on this count itself, my lord,
You have not filed your objections to this.
we will file an affidavit, my lord, all these three matters.
Why? We have been given sufficient time.
No, it
Notice
was
was
not-
issued. Notice was issued as far back as 27/9.
My lord.
My lord, so far as this particular objection is
My lord,
concerned,
7 days time will file, my lord.
my lord, so far as this particular objection is concerned, my lord, the department, the filing department, while accepting the filing, did not require for furnishing the board resolution. Otherwise, we could have furnished it the board resolution at the time of filing itself.
So who has signed the agreement? Where is the agreement?
Page 169.
169.
169.
This is executed by whom? Between whom?
The one side is chief engineer.
I think 171.
169 in Your Lordship. In the
It starts
left
from
hand side,
169.
169 ठेकेदार के structure.
No, it is the English version is there in 171 also.
Yes, Lord. Contractor.
GRJV.
Yes.
GRJV.
The petitioner is? Who is the petitioner?
GRJV.
GRJV. So you've entered a contract, executed.
Yes, GRGV is a joint venture, my lord. My lord, the cost title, if my lord will see at page.
You have
2.
executed a contract.
Yes. But my lord, this section 11.6, my lord, for filing 11.6, there has to be an authorization, board resolution has to be there by both the companies.
What provision are you saying that? Where is the manner? Where is the mandate of the?
It's a public limited company, my lord, or it's a legal entity.
That you should have insisted on while executing the agreement.
No, the agreement is signed
Now,
by an
not
attorney
only-
representative, my lord. That documents will produce, my lord.
Eh?
That is, but for filing this petition, there is no authorization.
Why should there be a separate resolution? It's
For
arising out of the
agreement,
same.
there is a power of attorney.
It is arising out of the same agreement.
Yes.
Which you have executed.
No, this 11.6.
No, why do you raise this
The
flimsy
affidavit,
objection?
my lord, which has been filed, my lord, will see the affidavit.
Lordship kindly
It is without
come
an
to page
authorization.
255, Lord.
There has to be a board resolution.
You should have filed your objection.
We file it, my lord. My lord will give you 7 days, my lord, time.
My lord, this objection, my lord,
File the
kindly sees the section 21 notice, which is at page 250. This section 21 notice was served on behalf of the joint venture, and they have responded to the section 21 notice, page 250, my lord.
He's entitled to file a reply because we have issued a notice.
Yes, my lord, they have sought for time on last several occasions.
We'll give them a final opportunity to file their reply. 7 days.
7 days. Ready, and
Where is that notice you are referring to?
250, my lord.
250.
Yes, my lord. Now, if you notice, kindly sees the on whose behalf this letter has been written. Our client, Messrs. JRJV, a joint venture of GPT Infra Projects Limited and Rahi Infratech Limited.
This is what is being objected to.
Now, this is yes. So this is the notice issued on behalf of the joint venture, comprising of two private limited companies. Now, kindly sees their response to this particular notice, which is at page 255.
Yes.
Now, this letter has been addressed to the joint venture company in response to that particular notice. without raising a dispute with regard to the authorization of this particular joint venture, or with regard to the authority of the advocate been sending the notice on for section 21. No objection at all. They have acted upon the notice issued under section 21 by issuing this letter. Not only that, thereafter there were several further letters also in continuation of this letter. Now,
Right.
kindly, since this
You
letter was
you
given-
file your objections within 1 week. We'll direct them to file their objections within 1 week.
and also, my lord, with regard to the point of the notice being issued on behalf of by an advocate, my lord, your losses has seen the order.
We'll hear you. We'll hear you on the next date on this issue, because
Madam,
let them
only-
file their objections, raising whatever objections they have.
Kindly grant them at 1 week's time, and another
We are fixing it on 18th, 18 December.
18 December. My lord.
You file it. You file it
Within
by 17.
after limited.
Yes.
My copy in advance copy may be served on us so that we can come back.
Serve advance copies to the local council.
Grateful, ma'am.
Heard learned counsels for the parties, Mr. H. Gupta, learned CGC, is granted final opportunity to file his objections in these matters. Let the matter be listed again on 18th.
Grateful, ma'am.
The objections be filed before 18th with advance copies to the respective councils appearing for the petition. List on
Grateful.
18/12.
Grateful.
Of separate. Item 7 is segregated from 8, 9, and 10.
May Lordship, please.
We'll continue with your hearing in the second half.
Lordship.
Second half, because this will be slightly longer.
It takes some.
Right. Second half.
Get 2 minutes.
Items 12 to 21.
Your Lordship, item number 40.
Huh?
Item number 40.
Yes.
The engaged senior counsel is having some difficulty.
Well, we'll start the hearing. You want to address which matter, Dr. Saraf?
16, 17, 21.
21 you also may take up.
21.
Kumar.
Pick it up on the reward.
The main issue, in fact, in this case is that whether service tax can be levied simply on the basis of the information gathered from the 26A statement from the income tax. Now, my lord, in this case, present case, my lord, the petitioner was rendering services to the Indian Oil Corporation and Oil and Gas National Gas Commission. Now, Indian Oil Corporation, the services which were rendered is by way of transportation, where by way of notification issued, the liability to pay the service tax was on the recipient of the services. And the recipient of the services has also confirmed
that the liability was on them and it has been paid. Now, in respect of the services which we have provided to the ONGC, my lord, the certain amount were deducted as source by the ONGC, which they have deposited, and on the balance, my lord, whatever amount was there, that has been deposited by Chalan, which is also there. Now, all these facts were brought to the notice of the assessing authority, my lord, adjudicating authority, when the matter was taken up. He directed us to give the documents and papers that were submitted. Virtual hearing was taken. That was also discussed. In spite of that, my lord, the so-called notice was issued, and we gave a reply also, pointing out about the IOC and ONGC that what is the details. Adjudication order was passed. In spite of that, on the basis, my lord, that 26A statement, the information shall be received. Now, this honorable court has already considered the issue, but that the 26A statement, on the basis of 26A statement, the service tax liability cannot be imposed. Because the tax cannot be imposed only on the presumptions, there must be a finding. If you also permit me, I may just give the copy of the order. Comparison will be, no? At page 95, my lord.
Yes.
And I will take your lordship to directly to page 97.
Para 6.
Where before that, my lord, the quotation portion I may take, my lord, 4.5, which is reproduced, my lord, in the middle of 97.
Yes.
From Form 26S, it appears that all receipts are from various government departments and other organizations for providing services which the said notice have claimed to be exempted under so-and-so, or the mega exemption notification number so-and-so, dated so-and-so.
This is 4.5 of the impugned or
Well,
order
that the order which was passed from
passed by the
mayor
authorities. Yes.
authorities. Notification number so-and-so. However, on perusal of the work order context vis-a-vis the Form 26AS, it is not possible to establish against which contempt they receive the amount reflected in Form 26AS. More so when many of the work orders are of the year so-and-so, the said notice did not submit anything showing in relation between the contempt and the entry in 26AS. Now we'll also see para 6. The liability to pay service tax is not on a presumption, nor it can be based on a state of intermediateness on the part of the authorities. The liability to pay tax has to be conclusively determined that for the given transaction for which the tax is imposed, the noticee is liable to pay such tax and the such taxes are not being paid. As the determination had not been made, we remand the matter back to the Principal Commissioner so-and-so for a phased determination. In doing so, the petitioner will be given an opportunity to produce any relevant material to show that the contract work for which the service tax has been imposed, the noticee is not liable to pay the tax for such transaction, and in doing so, the petitioner shall also cooperate with the authorities so that they also come with the conclusion that on the aspect and produce any relevant material as may be desired. After making the conclusive determination, any regent order further demand as may be called for may be issued by the authorities. On the other hand, if the conclusion that the petitioner is not liable to pay the service tax, appropriate regent order can also be passed in order to substantiate the claim of the petitioner, SSC, that they are not liable to pay the service tax. Any other ground or region as may be discernible may also be allowed to be raised by the petitioners. Now, this order has attained finality, my lord, because no appeal was preferred against the order. Now, this order makes it clear, my lord, that on the basis of 26A statement, only one assessing officer cannot come to a finding that all the services are taxable and thereby our service tax is to be paid. Now, my lord, a similar situation came up before the Sessions Kolkata, where the appeal was filed before this honorable court also. We'll also make an issue, my lord, the order.
Yes.
Well, para 12, you lost in kindly see, Milo.
Yes.
May I read, Milo?
Yes.
I find that service tech demand for the period from so and so is beyond the extended period of 5 years. I also find that the department had done audit of the appellant from as per the detailed manual scrutiny report, which includes the checking of Form 26AS as he mentioned in para so and so, circular number so and so dated so and so, and therefore no suppression can be alleged in the notice. I also find that as held in so and so, since the appellant was filing ST3 returns regularly, the department stated that it could not examine the factual position only on receiving the details in 26A statement cannot be sustained because CBC circular number so and so dated so and so categorically puts duty on the assisting officer to effectively scrutinize the returns and preliminary stage. I also find the proviso to section 73(1) has not been invoked to the operative part of the so-called notice, and therefore the extended period cannot be so and so held cannot be. I also find that invoking the extended period cannot be sustained for the part of the demand on so-called notice based or by virtue of the revenue neutral situation, since the appellant is eligible to pay it also. Thereafter, mirror so-called notice of 26 days per month, right? Now, in this case also, you'll also find at para 5, the addition was made on the basis of the 26 days statement. Just you'll also see para 5, Miller.
Para 5
of the judgment, Miller.
Which judgment?
This judgment, criminal judgment, Miller.
Tribunal. Yes.
Learned counsel for the appellant further state that even otherwise, it is type law that the figures in 26S are not to be used for determining service tax liability unless there is a proof to show that it was on account of any taxable service and it takes on so and so. Now, against this, an appeal was filed before this honorable court, Miller, by the department.
Yes.
And the appeal was disposed of only taking into consideration the interest part, Miller. Wrong, though in the appeal,
What happened to the SLP?
SLP is still pending, below. That is only on the interest part, below. That is not the question here. So other questions were not taken up. Although the appeal was filed, I've got a copy of the appeal also. You'll also
No, there is a reference to another writ appeal here, 160.
But that is also in respect of interest, below.
So perhaps that order.
I will give the order. So.
Whether it.
So that was the order which was passed against the lawsuit judgment, Miller. That wherein lawsuit says that the interest will have to be paid. An appeal was filed before the division bench. The division bench says that interest will have to be paid and subject to the result of the SLP which is pending before the Supreme Court. I'll give the judgment of both the judgments.
Okay.
Now here you'll also find this order has attained finality of the tribunal.
You are saying that the order of the sestate,
my lord,
was challenged in writ appeal 102.
No, in the Central Excise Appeal number 4 of 2022.
Okay, 4 of. Okay. Right. So why is this a writ appeal?
Well, writ appeal was in another judgment. All cases were taken up together. So
In a writ appeal.
Miller?
These were numbered as writ appeal.
No, Central Excise Appeal, Miller. You will also see.
No, this first case is shown as writ appeal number 102.
First is writ appeal, Miller, because that was a petition. And along with that, Central Excise Appeals were also taken up.
All right.
And at the time of hearing of the appeal as well as the Central Excise Appeal, the only issue was taken about the interest by the department. And the Excise Appeal was disposed of on that basis. So since the order of the sestate has not been interfered with, and the appeal has been disposed of only on the ground of interest,
This order attained finality.
that order has also become finality and attained finality because appeal has been disposed of.
Hmm.
बैठ जाओ फिर खड़ा कर देता है शांति लगता है ना बढ़िया
Yes.
No, my lord, apart from the, because the main ground which they were taking is the ground of alternative remedy. That there was a provision for alternative remedy is there in the act, and thereby the alternative remedy being there, the writ should not be, the power of writ should not be invoked. On merit, I will demonstrate to your lordship, my lord, that prima facie, the order is absolutely legal without jurisdiction. In as much as the amount of the services which I render to Indian Oil Corporation is not liable to be taxed, and there is a confirmation mailed from the IOC also that in respect of the services, transportation services rendered to them, the liabilities of theirs and they are paid. So far as the supplies made to the ONGC, I have paid the taxes. I have annexed all the challans. And in fact, all the documents were given to the authorities at the time when the 18 investigation started. I've given all the documents, but perhaps on 31st, when the matter was to be closed, my lord, they have passed the order simply without taking into consideration and by saying that no documents were furnished. Your lordship can imagine, my lord, when all the documents are available with me, I have furnished. They wanted balance sheet, they wanted 26-year statement, whatever they wanted, I have furnished it. And which SSC will not furnish the documents and papers which are in their position and by which the liability will not be there. And the assessing authority, the adjudicating authority is passing a simply a mechanical order. Without considering anything.
The impugned order is at page 63.
My lord, I'm just. Impugned order. Human file के तो सकता नहीं एक बार. Well, already page 63. I'm sorry, my lord.
63.
63.
Yes. I think we'll resume at 2.
Well, so in fact, the earlier coordinate bench has already passed the order. Now my efforts will be to satisfy your lordship on the alternate remedy.
No, alternative remedy is very clear that ordinarily you will go except for those exceptions.
No, there was one more exception, Lord, high-handedness. You know, normally you'll also find the natural justice without jurisdiction.
High-handedness would be arbitrary. Part of
But the Supreme Court has clearly said, Lord, the high-handedness, use the words, because normally the high-handedness words in your lawsuit will not find anywhere, the high-handedness. And I will also like to place before lawsuit that without jurisdiction, when we say, what does it mean? Whether without jurisdiction means that he had no power at all, that is without jurisdiction, or it means something more.
All right. Yes.
May I place some judgments on the alternate remedy?
Yes.
Hello, I've given a compilation.
Compilation of judgments.
My lord.
Judgments.
Yes.
Yes.
Lordship, first case I'm placing before Lordship.
Just 1 minute.
My lord.
Yes.
First judgment, an old case of the Assam High Court, a division bench judgment, my lord. I'll take your lordship, relevant part at page 4.
Yes.
Para 13.
Yes.
If therefore the existence of other adequate legal remedy is not per se a bar to the issue of writ of certiorari, and if in the proper case it may, for the duty of the superior court to issue writ of certiorari to correct the errors of the inferior court or tribunal called upon to exercise judicial, quasi-judicial functions and not to relegate a proper petitioner to other legal remedies available to him, and if the superior court in a proper exercise of jurisdiction in favor of the petitioner who has allowed time to appeal to spare or has not preferred the appeal, that is by furnishing the scrutiny required by the statute, it cannot then be laid down as an inflexible rule that the superior court must deny the writ than the inferior court or the tribunal, but by discarding the principles of natural justice and all acceptable procedure or principles of procedure, so arrived at by the conclusion which softens the sense of justice and fair play merely because such decision has been upheld by another inferior court or tribunal or appeal or revision. There may be conceivably cases where the error, regularity, or illegality touching to the jurisdiction of procedure committed by the inferior court or the tribunal or the first stamp of infirmity or vice instance is so patent and loudly obstructive that it leads to a decision of an indefferable stamp of infirmity or vice which cannot be obliterated or cured on appeal or revision. The Superior Court may quite properly exercise its power to issue the prerogative writ or certiorari to correct the error of the court or tribunal or the first tense, even if an appeal to another inferior court or tribunal was available and recourse was not had to it, or if recourse was had to it, confirmation what ex officio was a nullity. Para 16, my lord. It is true that we cannot judge administrative officer discharging judicial functions with the same strictness that we should judge a judge sitting in the court. A judge has to maintain certain standards of detachment and objectivity apart from being impartial, but an administrative officer has to do a considerable amount of administrative work, decide questions of policy, give directions, give instructions, which would be intolerable if they were to done in a judge sitting in the court. But this does not mean that although he may clearly express his opinion, although he may implicitly indicate that his views are the SSC, the SSC must still be compelled solemnly to go before him in appeal to hear an appeal the decision which he has practically already given so and so. There is no inflexible rule that the existing alternate remedy is a bar to the issue of writ of certiorari. The issue of various writ of the actions is in the discretion of the court, and the court, while exercising discretion, may take into consideration the existence of the alternate remedy as a matter of policy, but the existence of alternate remedy is not per se a bar to the issue of writ of the certiorari. Proximity page 5 below.
Yeah.
Para 19. In the case of so and so, the Supreme Court laid down what are the expression error apparent on the face of the record connotes. The jurisdiction of the High Court or certiorari may be invested. It is if it is only an error of law apparent on the face of the record, and not every error either of law or fact, which can be corrected by a superior court in exercise of its statutory powers as a court of appeal or revision. You also may come to page 8, my lord. Para 32. As I've already indicated, the existence of the alternate remedy under the Act is no absolute bar to this court granting relief under Article 226 of the Constitution. But as the remedy provided for in 226 for the Constitution is a discretionary remedy, the fact of an alternate remedy has to be considered by the High Court in granting relief under Article 226 of the Constitution. The proposition put widely that in no case where there is a complete machinery provided for under the Act for redress of the wrong, the High Court will exercise powers in the 226 Constitution cannot be accepted. Page 10, my lord. Page 10, Paragraph 42. No tribunal or and the officer can confer jurisdiction or authority or competence upon itself or himself by misconstruing a section. An authority cannot claim to exercise jurisdiction by construing a section erroneously and thereby contending that the section so wrongly construed gives him the necessary powers. In such a case, if the section has been wrongly construed, it would be a clear case of absence of jurisdiction apparent on the face of the court, because the court has to look into the section and to decide whether the officer construing the section was in the right or the wrong. The next line of argument of the Advocate General was that the jurisdiction of the income tax officer to assess does not depend upon the validity or otherwise of the notice under Section 22(2) of the Act, even though therefore it may be accepted that the notice is not proved to be properly served on the SSC. The assessment order in Section 23 cannot be said to be without jurisdiction. So in so, 11 my lord, next page, my lord, next judgment I'll place before Lordship, my lord. A division bench judgment of this honorable court at page 35. The 11th part at page 42, my lord. Paragraph 5. The foremost question is whether an alternate remedy or appeal provided in the statute bars the High Court to enter into a writ petition under Article 26 custodian. If not, what is the contour of the power of the High Court to interfere with the exercise of the powers in Article 73(4) of the State Duty Act? So may skip over page 43, my lord. From the last bottom, my lord, 8 or 10 lines, my lord.
Yes.
It has been observed that no warrant the entertainment to warrant entertainment of a petition Article 26, there must be something more to case which goes to the root of the jurisdiction of the officer, something which shows that it would be a case of culpable injustice to force the SSC to adopt the remedy provided under the Act. In so the Supreme Court remitted the case to the High Court, who had refused to interfere when the petitioner challenged an order of assessment of the sales tax officer. It has been observed that though ordinarily the High Court leaves an aggrieved person to take recourse to the remedies available under the ordinary law, if they are equally available under the ordinary law, if they are equally efficacious, yet there are certain exceptions, and one of the exceptions carved out, exception pointed out is where the action is being taken arbitrarily and without sanction of law. In so it has been ruled that the High Court has undoubtedly jurisdiction to decide this petition whether taxing authority allocated to itself powers which it does not possess or has committed serious error of procedure which has been affected the validity of the decision, or where the taxing authority threatens to recover tax on an interpretation of the statute which is erroneous. Now, in this case, my lord, he has the adjudicatory authority, my lord, assumed the jurisdiction on the basis of the statements under 26 AS of the Act, Income Tax Act. 26 AS is only in respect to tax reduction and source. That nowhere shows that whether the services were taxable or not taxable. Now that is, my lord, it says, my lord, either an error of law or procedure. Now, as you lost here, my lord, tax cannot be levied on presumption or analogy, my lord. He must come into the charging section. Now, if he has to come to the charging section, he must come to a clear finding that service was rendered, taxable service was rendered by the person concerned, which was taxable, and tax had not been paid.
Yes.
Without arriving at such a finding, the authority cannot assume the jurisdiction.
What is that form? AS.
Form 26 AS.
Yes.
Where the details are there of the tax deducted as source.
Yes.
Lordship may come to now page 47, my lord.
Yes.
in the middle, my lord, if any of the contentions
Yes.
if any of the contentions is allowed, the impugned penalty must fall through. This is also relevant consideration to hold that we must decide the questions arrived. We also find that the petitioner has claimed that the undisputed facts would show that the officer assumed jurisdiction to impose penalty on the act which he did not possess. The petitioner also claimed that the controller arrogated to himself the power which he did not possess and committed a serious error of law and procedure which affected the validity of the decision. The petitioner contends that the controller threatened the petitioner to recover the penalty on erroneous interpretation of section 72 and 73(4) of the Act. We are of the opinion that when the challenges in the petitioner go to the root of the jurisdiction of the controller, the writ petition cannot be dismissed without disposing the contention of the petitioner on merit.
Yes.
Here also you will also find the contention of the petitioner is that, my lord, he has no power and jurisdiction to levy the tax. More particularly, the procedure which has been adopted by the adjudicating authority for the levying of the tax, service tax in the present case, had no sanction of law because he cannot rely on such documents and papers relating to some other levy which had no bearing on the levy of the service tax in the present case, and thereby the adjudicating authority not only committed a manifest error of law, but also the error of procedure while levying the service tax in the instant case, and that goes to the root of the question of jurisdiction of the assessing officer, and thereby the alternate remedy will not come into way in entertaining the writ petition by your lordship, my lord.
Yes.
Another judgment, my lord, at page 56 of the Supreme Court. I will take your lordship to page 58, para 11. The respondent had a statutory remedy under section 107. Instead of availing the remedy, the respondent instituted the
You're reading from para 11.
Para 11 at page 58, my lord.
Yeah.
At the bottom. The respondent had a statutory remedy under section 107. Instead of availing the remedy, the respondent instituted a petition article 226. The existence of
Page number 58.
Page 58.
Para 11.
Para 11 at the bottom, my lord.
Bottom is provided further.
Just 2 lines, my lord, at page 58 at the bottom, my lord.
Para 11 begins with the appellate authority shall.
No, my lord, page 58, I think something wrong. No, can I check the comparison, my lord? My lord, at the bottom, the 11 is there, my lord. At the bottom, 2 lines.
Okay. All right.
That was with the quotation, my lord.
Yes. I get it.
The respondent had a statutory remedy under section 107. Instead of availing the remedy, the respondent instituted the petition article 226. The existence of alternate remedy is not an absolute bar to the maintenance of writ petition under article 226 of Constitution, but a writ petition can be entertained in exceptional circumstances where there is a breach of fundamental rights, violation of the principles of natural justice, and excess of jurisdiction, and challenge to the bias of the statute or delegated legislation. Now I am on the in excess of the jurisdiction.
Yes.
I have demonstrated before lordship that how it is, my lord, in excess of the jurisdiction. Now, at page 60, my lord, I have given the judgment of the tribunal, which I relied on earlier, my lord.
Yes.
I may skip over that one. Page 66. The famous judgment of in the Godrej Sarali, my lord.
Yes.
I may take your lordship to page 66,
No, 66 it begin.
68, I'm sorry, my lord. My lord,
Yes.
in the first line. In the long line of decision, this court has made it clear that ability of an alternate remedy does not operate as an absolute bar to the maintainability of writ petition, and that the rule which requires a party to pursue the alternate remedy provided in the statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementary, it needs to be restated that intertempability and maintainability of writ petition are distinct concepts. To find but real distinction between the two ought not to be lost sight of. The objection as to maintainability goes to the root of the matter, and if such objections were found to be of substance, the courts would not render incapable of even receiving the list for adjudication. On the other hand, the question of intertempability is entirely within the realm of the discretion of the High Court, writ remedy being the discretionary. A writ petition, despite being maintainable, may not be entertained by the High Court for very eminent reasons, or relief could be when refused to the petitioner despite setting up its own sound legal ground. If grant of the claim, relief claim would not further public interest. Hence, dismissal of a writ petition by a High Court on the ground that the petitioner has not availed the alternate remedy without, however, examining whether an exceptional case has been made out, or such a judgment would not be proper. Thereafter, the court has referred to a constitutional-based judgment, and at page 69, the Worldful judgment, my lord, again has been reproduced, my lord. I will not take your lordship, my lord, to that one. I will take your lordship to para 8, my lord.
Yes.
That apart, we may usefully refer to decisions of so and so, so and so. What appears on a plain reading of the former decision is that whether a certain item falls within the entry of a such text statute raises a pure question of law, and investigation into the facts is unnecessary. The High Court would entertain this petition in its discretion, even though the alternate remedy was not availed of, and unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the later decision, the court found the issue raised by the appellant to be pertinently legal, requiring determination by the High Court without putting the appellant through the wheel of the state appeals in the High Court. What follows from the decisions is that where the controversy is purely legal one and does not involve disputed question of fact, but only questions of law, then it would be decided by the High Court instead of dismissing the petition on the ground of alternate remedy being available. Now, here, my lord, the question of law which I am raising is that whether purely on the basis of the details taken from the 26A statement of Income Tax Act, the authority can assume the power to levy the service tax without examining whether the services rendered by the petitioner were taxable or not.
Yes.
Now, my lord, see me again, my lord, see kindly, my lord, page 9, para 9 at page 69. Now, reverting to the facts of the appeal, we find that the appellant had claimed before the High Court that the suo motu revisional power could not be exercised by the revisional authority in view of the existing facts and circumstances, leading to the only conclusion that the assessment orders were legally correct and that the final orders implemented in the writ petitions were passed upon assuming jurisdiction on which the revisional authority did not possess. In fine, the orders implemented were passed wholly without jurisdiction. Since a jurisdictional issue was raised by the appellant in the writ petition, questioning the very competence of the revisional authority to exercise suo motu power, being a pure question of law, we are of the view, consider view, that the plea raised by the petition did reserve a consideration of merits, and the appellant's petition ought not have been thrown out at the threshold.
Yes.
Now, another judgment I'm placing is page 80, my lord. The remaining part at page 89.
Yes.
Para 25 my lord. While we agree with the above principle, we are unable to appreciate the observations in the state case of so-and-so, which sought to put an embargo on the exercise of the jurisdiction under Article 226 of the Constitution, diluting a very significant provision of the Constitution, which also forms part of the basic structure. The principle of basic structure have withstood the test of time and are emphasized on many of the judicial pronouncements as an ultimate test. This is not something that can be doubted. That being the position, the self-restraint of the High Court and Article 26 Constitution.
Dr. Saraf, just a minute.
My lord.
Just 1 minute. Just 1 minute.
My lord.
Yes.
My lord. This is not something that can be doubted. That being the position, we see the self-restraint of the High Court and Article 26 of the Constitution of India is distinct from putting an embargo on the High Court in exercising jurisdiction under Article 226 Constitution while judicially reviewing the decision arising from the order of the tribunal. On the legislature introducing the concept of tribunalization, Lord, one may say that the concept has many questions marks vis-a-vis the different tribunals, though it has also produced some successes. The same is tested in so-and-so before a bench of 7 judges of this court. Thus, while upholding the principle of tribunalization under Article 323A of Article 323B, the bench was unequivocally of the view that the decision of the tribunal would be subject to the jurisdiction of the High Court under Article 226 of the Constitution and would not be restricted to the 42nd Amendment Constitution, which introduced the aforesaid 2 articles. In our view, this should be put to the matter to rest, and no bench less than the 7 judges could have doubted the proposition. The need for the observation of the 5 judges bench in so-and-so was the Armed Forces Tribunal necessarily arose because the observations made in the Major so-and-so Kant Sharma. This is irritated and clarified that the power of the High Court under Article 26 of the Constitution is not inhibited, and superintendence and control under Article 227 of the Constitution of India are somewhat different from the power of judicial review under Article 226 of the Constitution. So let's come to para 28 below. We may say with some experience of handling these matters to exercise jurisdiction under Article 226 prior to the creation of the Armed Forces Tribunal, but there used to be a large number of the pension matters. Persons who had served in the Armed Forces Tribunal left at the bay at the stage of the pension. This jurisdiction is also vested with the Armed Tribunal. If it should be difficult to say that there would be a larger public interest involved in a pension matter, but then for the concerned person, it is of the great importance to deny the High Court to correct any error which the Armed Forces Tribunal may fall in error, even in the exercising jurisdiction Article 226, would be against the constitutional scheme. The first independent judicial scrutiny is only by the Armed Forces Tribunal. To say that the same matters a judicial scrutiny would amount to second appeal would not be the correct way to look at it. What should be kept in mind is that the administrative jurisprudence, at least 2 independent judicial scrutinies, should not be denied. In our view, a High Court judge has immense experience in any exercise of the jurisdiction Article 226. The High Courts are quite conscious of the scope and nature of jurisdiction, which in turn would depend on the nature of the matter. Thereafter, let me see para 29. We believe that there is no necessity to carve out certain cases from the scope of judicial review under Article 226 of the Constitution, as was suggested by the Solicitor General. It was initiated in the Constitutional judgment in so-and-so that even in respect of the court-martial, the High Court could grant appropriate relief in certain scenario as envisaged therein if the said proceeding have resulted in denial of the fundamental rights granted under Part 3 of the Constitution of India, and the said proceedings suffer from the jurisdictional error or any error of law apparent on the face of the record. How can court countenance a scenario where even in the aforesaid position a party is left remediless? It would be neither be legal nor appropriate for this court to say something to the contrary or restrict the aforesaid observations initiated in the Constitutional judgment in so-and-so case. We would look to observe that any exceptions, including the ones enumerated by the learned additional Solicitor General, extracted aforesaid, is irrespective of the nature of the matter. If there is a denial of the fundamental right under the Part 3 of the Constitution, or there is a jurisdictional error or error on the facts of the record, the High Court can exercise the jurisdiction. There appears to be misconception. The High Court would reappreciate the evidences, thereby making it to second appeal. We believe that the High Court are quite conscious of the parameters within which the jurisdiction is exercised, and that these principles in turn are also already initiated by the court. Now, in this case, you'll also find the court referring to the 7 judges and 5 judges judgment said, my lord, that even it is not proper to carve out the exceptions for the High Court, that these are the exceptions only where the High Court should exercise. It is said the High Court judges are conscious enough of the limitations, and they will exercise their powers in a case where they should exercise. If any restriction is put on the exercise of power under Article 226 of the Constitution of India, that will go against the basic structure of the Constitution of India, and that is not permissible. So all the judgments which may not, that are placed before the court to say that the lawsuit cannot exercise the jurisdiction under Article 226 of the Constitution of India when the appeal is available, in my humble submission, that will amount to putting a fetter or embargo on the powers conferred upon your lordship under Article 226 of the Constitution of India, and no authority can whatsoever take away the powers of your lordship under Article 226 of the Constitution of India only on the ground that an appeal is provided in the statute. Lordship, see page 97, 95 already I placed below the judgment of the learned single judge of this honorable court. Mananjan Chakravarti. State of Tripura versus Mananjan Chakravarti.
Yes.
Oh, my lord, wherever you'll also find that the injustice has been done, or the authority has acted arbitrarily, or the authority has assumed jurisdiction which is not conferred on the authority, or the authority has followed a procedure which is not contemplated in law, your lordship, by exercise of the powers in 226, will certainly interfere, as it has been said, my lord, that 226 powers are beyond any technical barriers, and are to be exercised to wipe out the tears of the poor litigants. Now, on the one hand, the mighty union is there. On the other hand, my lord, the SSC is there, and the union is trying to impose a tax upon the petitioner, which the petitioner is not liable to pay, and thereby, under such circumstances, when the petitioner approaches before lordship, my lord, in my humble submission, the petition cannot be thrown out on the ground that the alternate remedy is there, and you go before the authority which has been constituted under the Act itself, who are the departmental officers.
Yes.
I was trying to lay my hand on the judgment of the Constitution Bench by Justice Hidayatullah, where it is said, my lord, when the appellate authority is manned by the departmental officers, and the tribunal is also from the retired officers of the department, it cannot be equated with the powers in Article 226 of the Constitution of India, because that remedy cannot be said to be an efficacious remedy. There is no judicial officer. The departmental officer is the appellate authority. And that officer cannot be said to be an authority to determine these questions. I will also make a similar short one paragraph judgment of the Supreme Court.
Yes.
I'll take you also to paragraph 4.
Yes.
For the reasons contained in the said decision, we hold that the impugned provisions are valid. It is of course clear that if gross injustice is done and it can be shown for good reasons, the court should interfere. Then, notwithstanding the alternate remedy, which may be available by an appeal under Section 20 or revision under Section 20, writ court can, in appropriate case, exercise in jurisdiction to do substantive justice. Normally, of course, the provisions of the Act would have to be complied with, but availability of the jurisdiction should not dispel any doubt with the citizens as against high-handed or palpable illegal orders which may be passed by the assessing authority.
Yes.
Now, here, my lord, in my humble submission, the order which has been passed by the adjudicating authority is clearly demonstrates that the same order, said order, has done not only gross injustice to the petitioner, but is palpably illegal and a high-handed order. And therefore, in my humble submission, the Lordship may kindly invoke the powers under Article 226 of the Constitution of India for giving appropriate relief to the petitioner. Raspberry. Calling you, Lord. हाँ तीन है, एक तुम्हारा कॉपी का है।
Anismenic.
My lord.
Anismenic.
My lord. The Lordship was earlier also had the occasion to.
Yes.
This judgment has been, my lord, dealt with in detail that what is the jurisdiction and what is the excess of jurisdiction. Page 25, Your Lordship can see.
Yes.
It has sometimes, the second paragraph.
Yes.
It has sometimes been said that it is only when a tribunal acts without jurisdiction that its decision is a nullity. But in such cases, the word jurisdiction has been used in a very wide sense, and I have come to the conclusion that it is not better not to use the term except in the narrow or original sense of the tribunal being entitled to enter into the inquiry, into the question. But there are many cases where although the tribunal had jurisdiction to enter the inquiry, it has done or failed to do something in the course of the inquiry which is of such a nature that its decision is a nullity. It may have given its decision a bad faith. It may have made a decision which it has no power to make, it may have failed to, in the course of the inquiry, to comply with the requirements of natural justice. It may, in perfect good faith, have misconstrued the provisions giving it the power to act, that it failed to deal with the question remitted to it and decided some questions which was not remitted to it. It may have refused to take into account something which was required to take into account, or it may have based its decision on some matters which, under the provisions setting it up, it had no right to enter into. I do not intend this list to be exhaustive, but if it decides a question remitted to it for decision without committing any of these errors, it is much entitled to decide the question wrongly as you do rightly. I understand that some of the confusion has been created by my saying in so and so that if a tribunal has jurisdiction go into the question, the jurisdiction to go wrong. So it has unusual jurisdiction in the narrowest original sense. If it is entitled to enter into inquiry and does not do anything of the things which I have mentioned in course of the proceeding, then the decision is equally valid, whether it is right or subject only to the power of the court so and so. Now, without the exceptions which have been given for the jurisdiction and that order to be nullity, in my humble submission, in all the exceptions, I fall into it because the authority has not examined the issue as per the procedure laid down, has not taken into consideration relevant materials, but has taken into consideration the materials which it should not have taken into consideration in passing the order, and thereby the authority although had a jurisdiction, but the order is a nullity.
Yes.
I may take a lawsuit, page 27, Milord.
27.
27.
Yes.
Last paragraph, Milord. This is a crucial case in this case. It appears from the Commission's reasons that they construed this provision as requiring them to inquire when the applicant is itself the original owner, whether he is a successor in title. So they made the inquiry in this case and held that so-and-so was the applicant's successor in title. As so-and-so was not the British national, they rejected the appellant's claim. But it on a true construction of the order, a claimant who is the original owner does not have to prove anything about the succession life title. Then the commissions made an inquiry which the order did not empower them to make, and they based on the decision on a matter which they have no right to take into account. If one uses the word jurisdiction in its wider sense, they went beyond jurisdiction in considering the matter. It was argued that the whole matter of construing the order was something remitted to the commission for their decision. I cannot accept that argument. I find nothing in the order to support it. The order requires the commissioner to consider whether they are satisfied with regard to the prescribed matters. That is, Milord, that is whether they are satisfied with regard to the prescribed matter. That is all they have to do. It cannot be for the commission to determine the limits of their powers. Of course, if one party submits to the tribunal that its powers are wider than that they are, in fact, they are, then the tribunal must deal with the said submission. Be it they reach a wrong conclusion as to the width of their powers, the court must be able to correct that, not because the tribunal has made an error of law, but because as a result of making an error of law, they have dealt with and based their decision on a matter with which, on a true construction of their powers, they had no right to deal. If they have based their decision on some matter which is not prescribed for their jurisdiction, they are doing something which they have no right to do, and so on. Here, the authority has no right whatsoever to levy the tax, service tax, on the basis of the data available in 26 years. The authority must come to a positive finding, firm finding, that the petitioner rendered taxable service and that taxable service is liable to be taxed under the Act. When the services which have been rendered by the petitioner are exempted, or there is no liability on the petitioner to pay the service tax because the liability is on the receiver of the service, simply on the basis of data collected in 26 years, the authority has no power whatsoever to pass the adjudicating order and levy the tax. I'm not burdening your lordship with the judgments, my lord. The tax cannot be imposed by analogy and presumption, and there is no equity in taxation. Your lordship is well aware of those decisions, my lord. That
You're welcome to bother us.
your lordship is well aware. I can only, my lord, burden your lordship with those decisions.
All right.
The taxing statute is only, my lord, as your lordship is aware, tax can be imposed when one comes within the four corners of the charging section. And charging section is that one must render the taxable service. If the authority has not arrived at a conclusion that he has rendered taxable service, simply on the basis of analogy, or I may say an apprehension that he might have rendered the taxable service, the tax cannot be imposed. Your lordship may kindly come to page 36.
36 of this
Comparison.
compilation.
So this judgment of the
This judgment.
Milo.
Ennis Manick.
Milo.
Yeah.
The last but one paragraph below. Five or 6 lines, 7 lines from the paragraph. If Parliament
Yes.
If Parliament has enacted that provided a certain situation exists, a tribunal may have certain powers, it is clear that tribunal will not have those powers unless the situation exists. The decisive cases illustrate the infinite variety of the situations which may exist and the variations of the statutory wordings which call for consideration. Most of the cases depend therefore on the examination of their own particular facts and particular areas set forth. It is, however, abundantly clear the question of law as well as fact can be remitted for a tribunal. If a tribunal, while acting within the jurisdiction, makes an error of law, which it reveals on the face of its recorded determination, then the court in exercise of the supervisory jurisdiction may correct the error unless there are some provisions preventing a review by a court of law. The lordship may skip over and come to page 37. Last but one paragraph below. If therefore a tribunal, while within the area of its jurisdiction, committed some error of law, and if such error was made apparent in the determination itself, or as it is often expressed on the face of the record, then the Superior Court could correct that error unless it is forbidden to do so. It would be forbidden if the determination was not called for in the question in a court of law. If so forbidden, it could not. Then even here arguments which suggested that error of law had been made, it could not, however, be still considered whether the determination was within the area of the supervision. In the present case, the question of forbidding the interference, Article 226 does not arise in certain cases, my lord. In the statute, the provision was there that no petition in the liability before so and so, and the apex court struck down that no such provision cannot be made, that the power on 226 or the going to the High Court, that power cannot be taken away by any legislature. So there is no provision forbidding the powers. The powers under Article 226 are, lordship's hands are very long, and your lordship's hands will reach wherever an illegality is there, wherever an injustice is there. 226 powers are available. The lordship may kindly see on page 39.
Yes.
Last paragraph. In his judgment in so-and-so, Kennedy J. noted the distinction between, on the one hand, disregarding the provisions of a statute and considering matters which ought not to have considered, and on the other hand, what is called a mere misconstruction of the act of the Parliament. Lordship may kindly note it, matters which ought not to have been considered. This perhaps illustrates the clear distinction which exists between error when it exercises jurisdiction and error in deciding whether jurisdiction can be assumed. In the latter case, an error may be consequence of that jurisdiction was lacking and was wrongly assumed, and the result would be that any purported decision would have no validity. Lordship may kindly turn to page 43. the last paragraph, my lord. It is sometimes the case that the jurisdiction of a tribunal is made dependent or subject to certain conditions. Parliament may enact that if a certain state of affairs exists, then there will be jurisdiction. If in such case it appears that the state of affairs did not exist, then it follows that there would be no jurisdiction. Sometimes, however, a tribunal might undertake the task of considering whether the state of affairs existed. If it made error in that task, such error would be regarded to a matter preliminary to the exercise of jurisdiction. Lordship may kindly see, my lord, page 44. In the middle, in his judgment in so-and-so, Lord Isher Amar pointed out that while it is generally correct to say that tribunal can give itself jurisdiction by a wrong decision on facts, there may be cases in which a legislature endows a tribunal with jurisdiction provided certain a state of facts exist, and further endows it with jurisdiction to decide without any appeal from the decision whether or not the state of affairs does not exist. That is to decide whether conditions precedent are satisfied or further exercise jurisdiction. The legislature may entrust the tribunal body with jurisdiction, which includes the jurisdiction to determine whether the preliminary state of affairs exists, as well as the jurisdiction on finding that it does exist to proceed with the so-and-so. Such a thing is not there in the case of the statute, the Finance Act 1994. No such power has been given to the appellate authority or the tribunal. You will also kindly see page 49.
Yes.
Second paragraph. Lack of jurisdiction may arise in various ways. There may be an absence of those formalities or things which are conditions precedent to the tribunal having jurisdiction to embark upon an inquiry, or the tribunal may at the end make an order that it has no jurisdiction to make, or it may intervening stage while engaged on a proper inquiry, the tribunal may depart from the rules of natural justice, or it may ask itself wrong questions, or may take into account matters which it was not directed to take into account. Thereby, it would be stepped outside the jurisdiction. It would turn its inquiry into something not directed to the parliament and fall to make the inquiry with the parliament did direct. Here, the assessing authority, adjudicating authority was never directed that you take into consideration materials, something outside other materials, and don't examine it and don't come to a finding, and simply based on that inquiry, you make the assessment. Lordship, ever under 148, when the information is coming from outside, and the assessing authority has not applied his mind at all, and on the basis of the state find matters itself, the assessment order is passed, the apex court has struck down the same on the ground that no, the assessing authority has not applied his mind. Simply information coming from outside will not be sufficient for the purpose of review of the text. There are some other paragraphs also on the same issue. I may at page 50.
Yes.
The fifth line, my lord, sixth line, where a decision is found to be in excess or without jurisdiction, there is strictly no need to quash it since it is nullity before issuing a writ of prohibition or mandamus. Then, the last but one paragraph, my lord, in so-and-so, Crab is in holding the decision of the assistant title commissioner was not in circumstances final and conclusive. Now it is general rule that no court or tribunal can give itself jurisdiction by wrong decision on a point collateral to the merits of the case upon which it limits jurisdiction depends, and however a decision may be final on all particulars making up together the subject matter, which if true within the jurisdiction, and however necessary to many cases, it may be for it to make a preliminary inquiry whether some collateral matter be or may not within the limits, yet this preliminary inquiry decision must always be open to the inquiry by the superior court. So, my lord, I submit respectfully before this honorable court, my lord, that without jurisdiction does not mean only that the authority has no jurisdiction only to enter, the power has been conferred. When somebody enters, assumes jurisdiction on wrong facts, by taking into consideration materials which are, he should not have taken into consideration, by not taking the matters which he should have taken into consideration by not following the procedure laid down in the Act, then that order will also be, my lord, in excess of the jurisdiction and will be nullity, and the lordship will, according to me, in that case, will step in under Article 226 of the Constitution of India and correct the orders and grant relief. Now, this is my submission on the alternate remedy.
Yes.
Clause 16, 17, 19, and 21
Oh.
of the list below.
Ah.
These are similar matters where 26 years statement is there. And I will submit my written submission also where the, my lord, the relevant part of the order where the 26 years, my lord, has been relied on.
Yeah.
Will place before lordship, my lord.
Yeah.
I'm grateful to your lordship for giving me patient hearing. Anil.
Yes.
Here also Mr. Kyal will submit on Thursday regarding the alternative remedy.
All right. Anyone else for the petitioner to submit on anything else other than what he has submitted?
And item number 13. In this case, actually the period of dispute is 2014 and 15, April 2014 to 31st March 2015. And the suppose is received on 26th of April 2021 after 5 years. That is completely barred by limitation. Secondly, I am executing the works contract on behalf of the railways, which is completely an exempted service.
You are
Executing the works contract on railways for digitalization of the computerization signal system in Northeast region and also other.
no, but it is only on the, it is also on form 26 years.
Yes, that is there. That side by side, my execution of the works are completely exempted. But keeping in view and after verification of my documents and works contract agreements, the department has imposed tax. That is reflected in the original itself. So that is completely beyond the scope of the authority of law and should be set aside.
You give a short written submission.
Yes, I can give written submission. Yes, I will do the one written submission. I will give.
Okay.
Lord, I am for 12. Facts is something different, my lord. Some facts is different. It is the so-called notice issued after 24 years. Some facts is different.
Limitation.
I replied my submission.
That is perhaps on the ground that there was suppression.
That is also 5 years. And this matter is already decided by this honorable. So that required a hearing by. Item number 12.
We are
BSNL.
hearing it.
I am ready.
Item?
Item 12.
12. Yes.
My lord, by this read petition, we have challenged the validity of the so-called notice dated 29/11/2021, my lord. 29/11/2021, and the disputed period is 1st December 1997 to 31st/3/2002.
Yes.
What happened in this case, my lord? I am the BSNL Assam Circle, having my 7 secondary switching areas, different switching switching areas, Your Honor, my lord. That is Guwahati, Kamrup, Jorhat, Silchar, Nagaon, Dibrugarh, Bongaigaon, Tezpur. All the SSS are independently registered with the service tax. All the SSS are submitted their return separately. But in the 28/3/2003, my lord, they've issued one so-called notice That is Annexure A, page 34.
Yes.
Same period, my lord. And in that so-called notice, my lord, they have demanded the amount of 3 crore 47 lakhs.
What service you had offered?
BSNL, that is the telephone service, my lord. Telecommunication.
Hmm.
Then, my lord, against that service so-called notice, adjudication was held, that is on 28/8/2008.
Yes.
That is Annexure B, page 38.
Yes.
By that adjudication order, my lord, the demand was reduced from 3.47 crores to 2.77 crores.
Yes.
Against that order, my lord, we have preferred an appeal before the state. That is the tribunal, my lord. And our appeal was registered as 198 of 2008. And department has also filed a cross appeal. That is registered as 210 of 2008. And by a common order, my lord, that is 31st/12/2018, state has allowed my petition and rejected the department's appeal. Against that common order, my lord, they preferred service tax appeal before this honorable court. That was adjudicated by order dated 12/2/2020, by order dated judgment and order passed by this honorable court. That is Annexure F, page 84. May lordship take that order.
84.
Page 84, my lord.
Yes.
This is the judgment dated 12/2/2020, my lord.
Hmm.
Administer this, para 2, my lord. The judgment and order dated 13/12/2018 passed by the learned Customs, Excise and Service Tax Appellate Tribunal says that this in appeal number this and service tax appeal number this have been assailed by the appellant in this appeal. Filed under
The question is in para 9, question of law.
para 9.
Yes.
Para 9.
So this is the question of law which was decided.
Yes, my lord.
How is this relevant for the present proceeding?
Because in this, the order was satisfied. By this judgment,
On
that
this-
order,
No, this is only on this question. You read the question at para 9.
whether the appellant court was correct in accepting the contention of the respondent BSNL that service tax is leviable on the actual receipt and not the gross receipt. While deciding this, this honorable court has also set aside the impugned order.
Where is the finding?
That is, my lord. For that purpose, my lord, may I take your lordship to para 11, my lord. Para 11. What was my submission at that time?
No, you show us from the order.
Yes, this is order, my lord. Page 88
88. Yes.
of the order.
Yes.
Responding to the said submission, Mr. Chopra, learned counsel for the respondent has argued that provision of Finance Act 1994 makes it ample clear that the service tax can be levied only on such items that have been held to be taxable. He submits that Section 65 of the Act of 1994 has defined taxable services, and therefore no service tax can be recovered in respect of gross receipt on account of any receipt which is not included within the definition of taxable service. It is also the submission of Mr. Chopra that by clubbing of assessment of different SSAs and by juggling the figures, the appellant had raised an erroneous demand in the so-called notice dated 28/3/2003 by including such item in the gross receipt component which were exempted from the taxable service. Here I am posing for the moment, my lord. What happened at that time, my lord? The taxable service is only the telephone service, not the other service like EPBX service, like the other services.
Yes.
The said error was rectified by the learned tribunal by carrying out reconciliation of the account, whereby it was found that no further amount was payable by the respondent. Under the circumstances, submit Mr. Chopra, no interference is called for with the input judgment and order dated 13/12/2018. We have gone through the material availed on the record and have also this is now para 13, my lord. As notice about the Central Excise Department had issued so-called notice dated 28/3/2003, raising demand of rupees 3 crore 47 lakh 49,000 on account of default allegedly made by as many as 4 different SSAs. That is Guwahati SSA, Jorat SSA.
What is
Silchar-
SSA?
SSA means switching, secondary switching areas. They raise the bills on their area wise. They raise the bills, they got the registration of under the service tax, they discharge the service tax. From a perusal of the so-called notice, it is evident that each of the 4 SSAs were maintaining separate account of gross receipt, and the demand of Central Excise Department is also pertain to the individual SSAs based on the record maintained by them. However, there is no indication in the so-called notice dated 28/3/2003 as to what was the amount recoverable against each SSA. 4 SSAs are there. What is against each SSA? The so-called notice dated 28/3/2003 also fails to give a specific particular as to the gross receipt of the respective SSA which were found to be taxable. From the so-called notice dated 28/3/2003, it is not possible for this court to infer that the non-taxable services had been excluded from the gross receipt for the purpose of computing the tax component. On the contrary, it appears that the demand pertaining to those 4 SSAs had been clubbed together, and the so-called notice had been served upon the Chief General Manager BSNL Assam Circle on a lump sum basis merely because he happens to be the apex administrative authority of the BSNL for the Assam Circle. What to be noted here in this so-called notice dated Itna, the Central Excise Department is alleging evasion of service tax and is also seeking to realize interest besides levying penalty. There is no dispute about the fact that for the purpose of recovering service tax, each SSA was to be treated as an independent entity. Therefore, it was incumbent upon the department to furnish SSA wise specific particulars of the default as to the enabling the notice to suitably respond to the allegation brought against it. However, as notice, specific facts and figures related to each SSA have not been mentioned in the notice dated 28/3/2003. From the order dated 28/8/2008, we also find that Commissioner of Central Excise had confirmed the demand of by reducing the amount from 3.47 crores to 2.77 crores, but such reduction is merely on account of exclusion of claim of service tax on account of Silchar and Jorat for the period from this to this. Save and except the above, there is no adjudication as to whether the demand of 3.47 crore is on the basis of gross receipt on account of taxable service, or it includes the entire gross receipt. SSA includes the non-taxable service. Now, my lord, I am escaping this a perusal of the demand, judgment, and order dated is not passed by the system. Now, my lord, finding is from
But here,
17.
here,
Same so-called notice issue.
no, same so-called notice, but you did not go before the tribunal. You have come to the court
Against the so-called notice, we came to the court.
against the so-called.
2 reasons, my lord.
Whatever it may be, but
My lord.
this is a case, this appeal is directed against the order of the sestate.
Sestate.
But in your case, you are not challenging the sestate order. Here.
That sestate order is in my favor.
Maybe-
So I have not challenged.
No, here. In the present petition.
This is the read petition, my lord.
That's right.
Yeah, my lord.
We are asking. The finding here is that sestate cannot step into the shoes of the assessing officer. That is the finding.
My lord.
Therefore, it was interfered.
My lord. Then again, my lord,
Hmm.
so far the adjudication order is concerned and so far the so-called notice is concerned, that is also interfered by this honorable court in this order itself. That is at page number, my lord. May I take your para 17 of this order, my lord. From a careful analysis of
We
the,
have seen that, yes.
we find that the learned sestate has carried on this.
The last lines of that paragraph. This is the ratio of the judgment. In
Input order dated now was not sustainable in law. That is so far the tribunal's order is concerned, my lord. Now, my lord, para 18,
That's why we have read it.
my lord.
Yeah.
Para 19, my lord. Although we are in agreement with the submission of Mr. Chopra that the impugned so-called notice suffered from certain vital deficiency, yet we are also with the view that learned sestate was not correct in carrying out the independent assessment of the text liability of the respondent and thereafter recording a finding of the fact by obtaining certificate from a chartered accountant from the reason stated about the input order. This is the order, my lord.
This is the order of the estate.
No, my lord, this,
This is the order of the estate. What is that impugned order?
just minute.
Said this is a central service.
This is the order of the state, my lord.
That's right.
Again, my lord, is held to be unsustainable in the eye of law and same is accordingly set aside. Correct, my lord. The so cause notice dated itna is also stands interfered with. Again, my lord, we however make it clear that notwithstanding this order, it will be open for the appellant to issue so cause notice raising demand for recovery of service as may be permissible under the law.
Therefore,
Such demand,
Therefore, Mr. Chopra,
my lord,
please come back to para number 9. This is the question of law to be decided by the court. Para number 9.
my lord,
So on this, the order of this estate was set aside.
set aside. And the order in original was also set aside, my lord. Kindly see the para 21, last paragraph. Upon receipt of such notice, it will be open to respondent to avail all procedural safeguard. As may be, we also make it clear, my lord, here. We also make it clear that the order dated 28/8/2008 shall cease to have any effect.
What is this 28.8?
Order in original. That is the earlier so cause notice which was adjudicated.
Right, because the show cause notice was interfered with, original
Interfered.
show cause notice.
So that order was also. Now my humble
The
submission.
further appeal against this order?
No, this is the final.
You don't have instructions or you don't know?
Your Lordship, I don't have instruction.
Say that. Yes. Otherwise, it is a question of the same issue, that your alternative remedy. And your assessment is based on the form 26 years.
26. Apart from, it is not formed on the basis of 26 years, my lord, but their alternative remedy and my submission, my lord, it is absolutely time barred. Now the present so cause notice is issued after 18 to 24 years.
All right, you give a list of.
But, my lord.
Anyone else?
Item number 15 is separate, my lord. Here they have filed a affidavit in opposition. I need to file my reply. It will be taken after vacation, my lord. They filed
Let it remain in the same matter. We'll hear what Mr. KL has to
My
say
lord.
in that respect.
My lord.
Heard, learned. Dr. A.K. Saraf, Senior Counsel, assisted by Mr. A. Goel in WPC so and so number kettle available. Mr. B. Sahu appears for WPC. How many petitions? One. Mr. Chopra for? How many petitions? One. Okay. And yes, Miss.
Item 20, Your Lordship. Interim order may kindly continue similar matter.
Oh, we are passing an order. Hang on. And have been heard. Counsel appearing on behalf of the respondents. Praise for furnishing of, praise for replying arguments on Thursday. Which is on 12th. Thursday is all right for you? Thursday, 12th. All right. Let the matter be listed again on Thursday. Interim orders, wherever passed, will continue until the next date fixed.
Can it be Friday?
Not Friday. Thursday, let it be on Thursday. Let us see what reply comes.
For further hearing.
For further hearing, yes. Matters have been heard in part for further hearing.
One similar matter is pending. Can it be tagged, madam?
You make a mention on Thursday. You make a mention before the court.
Tomorrow,
We'll pass
tomorrow I
it.
will mention. madam.
Yes.
I'm a pleasure.
Item number 11.
Hey, please, Your Lordship. Senior is on lag in court number 98. Can it be on 16th of December?
Is something to do with what? That land ceiling? No.
No, Your Lordship. My land was used as a garbage disposal area.
Oh, okay. Oh, all right. Yes. 16? 16?
616. Highly obliged.
Attendance report listed on 16th, Mr. PJ Talukar, senior, additional senior government advocate, appears for the response. Yes.
For hearing item number 22.
The last occasion, my lord, your lordship was pleased to direct them for obtaining update inspection, my lord.
Who's for the education department?
Sharma was there, my lord. I talked with him, my lord. He said that he had not got the inspection yet.
Who?
Sharma.
Scroll. Scroll. Education Standing Council. All right. Just for the time being. Yes.
That is 25 and 26.
It's free to be okay.
I'm paying for responding number, my lord, 3 and 4. Yeah.
Who's for the petitioner? None appears. None appears for the petitioner. Mr. A.K. Gupta appears for respondent 4 and 5.
I'm for 2.
3 and
MS, huh?
3 and 4, my sorry.
3 and 4.
Three.
And MS PR Monto 4.
No, my lord.
No.
In item number 26 to item number 25.
Huh? Respondent 1 and 2.
1 and 2, my lord.
1 and 2. Please after in the month of January.
Obliged, my lord.
On a date to be fixed by the registry.
Deeply obliged.
That is 27.
Here the respondent appears in person, is from outstation. The lordship may fix in January, lord.
Mr. B. Chakraborty appears for the review petitioner. He fairly submits that the respondent appears in person, who is not available in court today. Therefore submits that the matter be listed in the month of January. Accordingly, list again in the month of January on a date to be fixed by the registry.
28.
My learned council is went to the washroom only for the timing. My learned council went to the washroom for the timing.
There's no time being, it comes up next week.
Yes, lordship, some urgency.
Whose urgency?
He said, my lord, his senior my lord said some urgency is there, my lord. No, my lord, that matter, my lord.
Who is, huh?
I am for the respondent, my lord.
All right, let it come, passed over, we're passing it over. If it comes down the week, we'll see.
Lordship, kindly, just few minutes.
Not few minutes. It'll come up on Thursday. Thursday.
On Thursday.
Yeah.
Obliged.
Obliged.
Oh. Mr. S. Hawk appears for the petitioner, none appears for the education department. List again on Thursday.